Brother, you are there online?
Yes, yes.
In view of the aforesaid facts and circumstances, we have the considered opinion the material in this case would not be sufficient to come to a conclusion of guilt, and that the same has been proved beyond all reasonable doubt. You are of the opinion the benefit of doubt has to be given to the appellant. Appeal is allowed. Much obliged.
Yes. Qualification fee.
Yes.
My lord, I beg to make urgent motion, my lord, to be listed tomorrow.
Tomorrow is.
May
Matter.
please, your lordship. I
Yes,
recommend
Mr. A.
No, no, in this case, I am.
26, my lord. Item number 26, my lord.
Yes.
We require some time for instruction, madam. Matter maybe come on midweek of 11 August 11 or 11, 12, any date, my lord.
In this case, Lordship, we are filing an additional affidavit also.
Okay.
So let it come after 4 weeks. The interim order passed earlier may continue till then.
Yes, what do you say?
My lord, 4 weeks, my lord, interim is continuing, my lord. That
Oh, then 3 weeks.
3
2
weeks.
weeks, my lord. Yes.
While Miss A. Gayan, learned CGC, has paid for an accommodation, comma, Sri D. Sekyal and Senior Counsel for the petition has submitted that an additional affidavit is required to be filed and accordingly some time is to be given. Full stop, para. List after 3 weeks to enable filing of additional affidavit, para. Interim order passed earlier to continue till the next date of listing.
So blessed.
Yes.
My lord, I beg to mention, my lord, one IA, my lord, file for correction of order, my lord,
When? Tomorrow?
by tomorrow, my lord.
My please, Lordship. Lordship, with the consent of the other side, I beg to mention item number 16 and 17, Lordship.
16 and 17, yes, please.
Lordship, can
Yes.
it be on the next week, Lordship? Yes,
These are old matters.
yes, Lordship.
16, the 2015 matter.
Yes, Lordship.
How can you adjourn a 2015
What
matter?
happened, Lordship? The existing counsel, Mr. K. Kalita, is going through some medical emergency in his house, Lordship. Due to which he failed to inform the senior counsel, Mr. B.D. Das, about the case being listed today, Lordship. So
You're mentioning which item? Item number?
16 and 17, Lordship.
16 is the respondent lordship, 17 is the petition.
15 matters, we do not adjourn.
We are short.
We'll have it on Tuesday.
Tuesday, next
Tuesday.
week, Lordship.
A prayer for adjournment has been made on behalf of the respondents. Respondent number
Respondent 4 and 5 in the first
4 and
item.
5 in WPC 463/2015, who are which place is this? Guwahati.
What?
Yes,
Who are the petitioner? Who are the petitioners in WPC 1236 of 2017? It has been. They said adjournment has been cited on medical grounds. Para, considering the ground, a short accommodation is granted as these matters are pending since the year 2015. List on Tuesday next for hearing.
Hello, Mr.
Is there anything left in these matters?
As of the both of us are running, lordship. Both of us are in relation.
Yes.
Yeah, Lordship. Lordship, item number 6, my lord.
Yes.
In this matter, in the last week, the government has filed affidavit, my lord. I want to file a reply, my lord. 2 weeks time may be granted.
Yes, item 6.
Lordship.
On a prayer made on behalf of the petitioner, 2 weeks' time is granted to enable filing of rejoinder affidavit.
Lordship.
Item 6.
6.
Yes.
Lordship, I am for. I am not in item 5. But.
Next. I know.
Lordship,
Want to withdraw this?
Lordship, there was non-constitution of the bench, Lordship, by the Assam Board of Revenue. Now it has been constituted, we have been informed. of it.
Okay.
So may I pray for the liberty, Lordship, if you please.
No, that liberty is very different. Heard Sri H. Betala, learned counsel for the petitioner. Who is for the taxation department, finance, yes. Also heard Sri B. Chaudhary, learned standing counsel, finance, taxation department, para. Sri Betala, the learned counsel, has submitted that the cause of action was with regard to non-constitution of the Assam Board of Revenue.
Assam Board of Revenue, third position member.
However, after filing of the writ petition, the board has been constituted and therefore he submits that there may not be any live cause of action to be adjudicated. Correct? In view of the above, the writ petition is dismissed as infructuous.
I'm deeply moved.
Item number 1 and 2, similar matter is in fact covered.
Oh, Lordship, it will cover. It will cover.
Covered.
Right.
This is, I have made corrections also.
Have you seen the correction?
Correction,
Yes.
only dates and all.
Okay, A Goel, B Chaudhary, yeah? Correction for this. Okay. Disposed of,
It was,
Yes.
both.
1 and 2. Yeah.
Please indicate the numbers.
I have written, my lord, number and all. Deeply obliged.
May I please, my lord, I am praying for a short accommodation, my lord. Item number 23 and 24, my lord. We are led by senior counsel, my lord. Can it be taken up after some time, my lord? He is on leg, my lord.
After some time.
After some
Yes, same eviction matter.
eviction matter, my lord.
Who is your senior
My lord, Mr. Ken Chaudhary is appearing, my lord.
and Mr.
My
Ratta?
lord, similar matters.
By matters of similar impact, similar, notice will with the, non-forest land by the forest department.
Fine.
Non-forest.
Forest land, my lord. I have received instruction from DFO as well as from DC, but in this case, my lord, they have come up with a document showing that it has dag and patta. So my suggestion would be, my lord, that before the eviction, let there be joint verification by forest and revenue authority. That is what precisely.
We will ask you to have instruction. It may be slightly different from the other cases.
My lord, my lord.
You just cannot go for, since prima facie they are trying to
Yes,
project.
my lord.
That's what I'm saying, my lord.
Let Mr. Chaudhary
Well,
come.
Well,
But you can inform him, you can record
Yes,
his
yes, my lord,
presence and
just
pass the
he-
order.
my lord, he
Just
will-
inform him.
Yes, sir. He'll come, my lord, within a short 5
No,
minutes.
no, you can inform, even without coming, you can record his presence, that's not a problem. If this is the order we are going to pass.
My lord, my lord.
We are also led by my lord learned advocate general.
We'll record presence of both. Have their consent, we can pass order
Mile.
instead of waiting. Yes, next.
Obliged.
Wait, please, your lordship.
Yes.
My lord, this petition is against my lord threatened eviction from their patta land by the railways.
Patalan.
My. So what happened, my lord? All these petitioners purchased this land with due permission by registered sale deed. Their names have been mutated.
What
And,
kind of land is this?
My lord,
What kind of land? Land is Patalan.
patta land.
No, you, who was your vendor?
The vendors are, my lord, the sale deeds we have enclosed.
No, you have done due diligence. The vendor had title.
Yes, my lord. Vendor has title, then our names have been mutated. We're paying taxes and my lord, revenue also, of course, of late, they have stopped my lord taking revenue. After this.
Now, on what basis you are being sought to be declared as an encroachers?
Now, my lord, the stand of the railways is that the land was acquired in 1959
By the railways?
by the railways. A big plot of land was acquired for the purpose of construction of the, my lord, Horaighat Bridge. And this was a part of the approach road, that is their case. Therefore, my lord, this honorable court eventually, although my lord, all the documents the petitioners has showing that the land is patta land, then my lord, the registered sale which are there, names are mutated. Then eventually, my lord, your lordship may kindly see the order dated 13/2/2025.
13-2.
My lord, 13th of February 2025.
Yes.
That order, your lordship may kindly read.
Yes.
And an affidavit was directed to be filed.
Has it been filed?
That has been filed, my lord. But then, my lord, that does not really answer the questions of the, my lord, of the court. because they have not been able to show, my lord, with proper documents that the land was acquired or that, my lord, compensation has been paid. Only some, my lord, draft communications have been sent, some sanction has been given. My lord, that's a, my lord, 1959 acquisition according to them. Bridge was completed in 1962. And all these years, my lord, nothing has happened. So, my lord, the land was actually not required. And the authorities also granted permission for the purchase of the land and construction of the houses also, my lord. All these families, they are, my lord, 37 in number. They have their constructed buildings there. And that is how, in fact, my lord, what happened, that is a part of a land which is, my lord, Dag number 13 of Patta number 19. The land in respect of which, my lord, these persons have been, in fact, my lord, there was a notice by the DC to all the, my lord, patta holders to show their documents. And, my lord, documents were shown, and my lord, no order was passed by the deputy commissioner. Eventually, my lord, some other, my lord, similarly situated persons, they had approached the civil court. And the civil court, my lord, passed a decree in their favor. These petitioners, my lord, did not join them. That is the only difference with the, my lord, decree. Thereafter, my lord, the matter eventually came to this, my lord, honorable court, and there is a judgment of this honorable court that your lordship will find in the affidavit in opposition of the respondent number 4, deputy commissioner, at, my lord, page 336. That is the order passed, my lord, by this honorable court. That is the, my lord, affidavit in opposition of the my lord, deputy commissioner.
Now, what is your cause of action? Which order? Is there any communication?
There was no communication as such, my lord,
So on apprehension?
on apprehension, my lord.
Okay, what do you say, Mr. Bhagat? You are for the railways? Are you, is there any move to evict them?
My lord, we have not issued any notices to them, my lord, other than PP Act, my lord, till now.
Then we can record this. And this, since this matter is pending since 2017,
17,
you are
my lord.
protected by an interim order.
A delay was not because of the petitioners, my lord, because the court at different point of time, my lord, asked for different information. And, my
No,
lord,
we are not on
lord.
that. You have misunderstood us. We are saying in 17, you had moved, there's an interim order protecting you.
Yes.
We'll try to make that interim order absolute and say that if anything has to be done, it has to be done in accordance with law.
Law, my lord.
Either you have to acquire fresh, and for that there has to be a need of the land. Since the bridge has been constructed long time back,
Yes.
whether there is need of the land presently occupied by you as patta holders. What do you say?
My lord, till 1099, my lord, the land was in the name of the railway only. But suddenly in
1999.
99, the DC converted that land into a patta land. But thereafter, seeing the mistake, my lord, it was again converted to railway land, my lord. Those documents are filed along with the affidavit, my lord. And they say, my lord, since the other persons, they had got a decree in their favor, but that is with regard to only 4 acres of land, my lord. They said, we are similarly situated, so this is our land. And all those things, my lord, actually,
I think your ideal course is to approach the
a
civil
civil
court.
court, my lord.
My lord, they have not issued any, my lord, notice of eviction.
No, so far, see, you are relating your right to the sale deed from the original landowner, your vendor.
My lord.
Now, they claim that this is railway land. So your vendor probably did not have any title to be transferred. You need to have a declaration.
No, my lord,
My lord, in fact, the affidavit filed by the government also says that the plot of land it belongs to the railway. The name of railway is recorded in the Sita also, in the Jamapandi also.
if your lordship kindly, my lord, goes through a part of the judgment passed by this honorable court, my lord.
In the civil court.
No, my lord, in the civil court and which was eventually, my lord, upheld by this honorable court. That judgment will
Let
make
us
it
see
clear.
which page. Which page?
That judgment your lordship will find at, my lord, page 336.
336.
336. Yeah, so it will be here for more valuable.
336, yes, please. Is this a letter of 1 to 18?
My lord.
1 to 18? By the district administration to the railways.
My lord.
Is it correct, Mr. Chaudhary?
Just a moment, my lord. So many, it has become so voluminous. Because this pertain to, my lord, only 4 bighas of land, but the entire land, Doug number 13, my lord, that is the issue, because we are also in Doug number 13 of KP Patta number 109.
Now, what do you want to show in 336?
In this judgment, my lord, the honorable court has.
No, 336 is not the judgment. You want to show a judgment? Mr. Dotto? You're just sitting tight, you're not assisting. Show us the page.
It's fine along with affidavit.
Government.
Connected to the government affidavit, my lord.
Can you give the page?
Page number 338.
338.
Lordship. But that is the affidavit, my lord.
No, 338 is something else.
You have marked it that way. So, the government affidavit, no.
In the affidavit of the, my lord, deputy commissioner.
Judgment by whom? Is it 15/11/2023?
My lord, by Honorable Justice Debashri Kaur.
Oh, that starts in 300 and
It for
360. 360. Annexure 4, is it?
Last at least 334, my lord. Internal affidavit filed by the deputy commissioner on 19/6/2021.
No, there are 2 page marks. That is the difficulty.
There's a confusion, my lord.
Is it the judgment is dated 15/11/23?
15/11/20. Yes.
Yes.
Which internal page? Refer to the internal place, please.
Internal page. Internal page, my lord, page 4.
Yes, 4.
It starts at page 4.
Yes, yes.
May I read it, my lord?
Yes, please.
The instant with petition has been filed by the petitioner seeking a direction upon the respondents, more particularly the respondent number 1 and 2, not to evict them and to demolish the buildings situated in Doug number 13 of KP Patta number 109. So this is, my lord, Doug number and Patta number of the petitioners also. The facts, as can be discernible from the materials on record, reveals that the petitioners as well as the predecessor in interest have jointly filed a suit, being titled suit number 100 of 99 against the Union of India, represented by the General Manager, Northeastern
But the premises of this judgment is a decree.
Yes.
If you come to the operative part at internal page 9,
Fine.
there are 2 directions, one to demarcate and one has a reference to the decree which was passed on the behest of these petitioners, which is not your case.
It's not my case, but my submission before Lordship is that, my lord, it is the same Doug number and same Patta number, comprising total, my lord, 13 bighas of land. My lord, in respect of 4 bighas, they have, my lord.
Now see, there are counter claims. You are saying that you had purchased the land from the vendor, names have been mutated, the sale deed is registered, there is no flaw with the process. But they are saying that this land is originally railway land and still continues to be railway land till the year 1999.
When it was converted to Sarkari land, my lord. Thereafter again reconverted to railway land.
My lord, the lands were purchased by the petitioners at different point of time, starting from
2000.
1995.
No.
95.
Yes, my lord.
99.
1995 to 2007, my lord. 1995 document your lordship will find at page 29. That is the.
What is the necessity of the land, railway land? Is it in the vicinity of the railway line?
My lord, that is Sarajat Bridge, that's the land nearby.
There's a part, my lord, by the side of the approach road. Towards
Beside the national highway, my lord.
which were never utilized, my lord, they didn't require it also.
Can we overlook the aspect of public interest?
No, my lord, so far as my lord, the public interest is concerned, the land for the purpose of which my lord allegedly they wanted this land to be acquired, that purpose has been served in 1962. My lord.
What is the vicinity of the plots from the railway line?
It's within the railway.
What is the distance?
From the railway land is, my lord, the approach road was railway land, my lord, that was made circular. The railway track, my lord, that is that.
From the track, what is the vicinity? What is the distance from the track?
In between this, my lord, the approach road and by the side.
It's automatically.
How can we say that unless a civil court really goes into it by evidence?
Perhaps, my lord, the.
And in fact, my lord, in the judgment, in the last 4 lines.
We have seen this.
Full court has
We have
clearly-
seen this.
clearly
Last
stated,
4
my
line.
lord.
Until that decree is set
Decree is set
aside
aside.
in accordance with law.
and
They were
again,
armed
have
with a
initiated
decree.
Process, my lord.
They were armed with a decree, which is not your
We
case.
are not, we are not.
But still then, we may treat you almost at par.
Perhaps, my lord, whatever has fallen for him.
But the last part, protection will not be there till the decree is set aside. We may still pass an order to demarcate in accordance with law, if that serves your purpose.
Giving proper notice, my lord, as required under law, my lord.
But what about the ownership issue? Who will examine, who will decide?
That matter, that liberty is always there with the matter petitioners to approach the civil court if necessary.
Yes, Mr. Bhagat. You have filed affidavit.
Lordship.
Railways, when?
My lord, regulars have filed 2 affidavits.
My lord, 22/5/24, there's an AIO, and thereafter additional affidavit was filed, my lord.
22/5, 24.
22/5/2024.
And this is the first affidavit in opposition. An additional?
Additional affidavit.
My lord, additional affidavit was filed on my lord 12th of March 2025. That is at page 423, my lord,
22/5.
in my record, my lord.
My lord, so
Railways respond number?
1 and 2, my lord.
1.
1 and 2. You filed on 13/3/25, 1 and 2 when? 4, who is 4?
That's
Four-
not for the deputy commissioner.
4 filed on 26/20/24, okay.
26.
24/5. 1 and 2, 24/5, you have filed 24/5, okay. And you filed affidavit. Right. Additional affidavit 13/3.
These are the dates of the affidavits if your lordship.
We have this. And R4 filed on 26/24.
Wait a second, affidavit can file, my lord.
What is your case, Mr. Borgotak? What is your case? What have you pleaded?
My case is that, my lord, this land was acquired for the railways by the state government, my lord. And we have paid the money also,
Acquired when?
1959, my lord. And advance possession was given to us, my lord. And since then, my lord, we are in possession of that land.
If they're in possession of the land, my lord, there is no question of eviction.
Railway land is a long land.
You have your residences there or
Yes,
what?
my lord. We have got our buildings there with due permission from the my lord authority.
You are not in possession of what?
It cannot be.
We are in possession, but
If they're in
if
possession,
lordship can see that near the railway lines, they all make illegal, and thereafter we vacate them, then again they will. But whenever it's necessary for us, my lord, we
59, the land was acquired for you. You had made the payment. Possession was handed over. And what happened in 1999?
99, my lord, without issuing any notice, the DC converted that land into a government land, my lord. And thereafter, they started purchasing those lands, my lord.
No, they purchased in 95.
That I do not know, almost all the documents, my lord, that were annexed, my lord.
No, if it was
99 and thereafter, my lord.
even if it was converted to government land, how do they purchase the government land?
That
Only
we
the
do not know,
possessory
my lord.
right or what?
That we do not know.
Possessory right.
Only after filing this case, my lord, we can decide.
Your lordship will kindly see the.
Your vendor had a patta.
Yes, my lord.
Let us see your vendor's patta.
My lord, the sale deeds, if your lordship kindly comes to,
Was there a due diligence done on before the purchase?
my lord,
Was the due diligence exercise done before the purchase regarding the title of the vendor? That perhaps was not done.
Not done.
but their names have been mutated subsequently.
Yeah, mutation is on a subsequent aspect we'll appreciate, but here, Mr. Borkotaki says that 59 it was acquired, then 99 without notice it was converted to khas land.
My lord.
So either before, after 59 till 99, it could not have been sold by any other person except the railways, which was not done. So your sale deed is by a person without any title.
My lord, in fact, that's their statement, my lord, in paragraph 4 of the repetition, my lord.
What is the
That it is pertinent to mention here that as per order of the settlement officer dated 10/5/99, passed on the basis of the order dated 18/4/99 issued by the government of Assam in reference to the letter number such and such, the entire land measuring 64 bighas 1 kata of 6 and 6 lesser pertaining to NK Patta number 1 was converted to KP Patta land and KP Patta number 109 was issued. And thereafter, my lord, in 2001, it was again
I
converted
think
to.
your best course is
that too
to
without
is
issuing
to
notice to
approach
the
the
railways,
civil
man.
court. Best course is to approach the civil court.
That is
We'll
their
protect
statement.
your right till you file and pray for injunction, whatever. Other than that, it will be difficult.
That, my lord, the first thing your lordship.
We cannot even ask for demarcation unless these are
My
the
lord, in
questions
fact,
of
they
fact
said
which
that
are
out of the
disputed.
land measuring 30.
He may not be what he's submitting. It may not be true as per the records. You
My
have
lord,
to.
they have not been able to show that, my lord, the land has been acquired. That, my lord, that is the direction of this honorable court to produce the documents to show that land was acquired and that, my lord, payment was made.
No, my lord,
To
then
the
all the
landlord.
notifications are there, section 4 notifications, section 6 notifications are
So
there.
these are only
And
drafts.
only, my lord, all the full payment, those documents are not with us, my lord. It has been misplaced or perhaps lost. I don't know what has happened. They have not provided me. But a part payment of 5 lakhs rupees are there, my lord, at point of time. We have paid.
These are only, my lord, the.
No, these matters you can contest in the civil court. Here it will be difficult.
267.
Here it will be difficult. And when it comes
267.
from a government organization, we are not saying that what they are saying is sacrosanct. But normally we have to.
But their statements are not supported by documents, my lord. That is what the.
267.
Let us see the statements, Mr. Borgoto. Were the statements in your affidavit where you have mentioned about making payments? First affidavit,
Oh, my lord, in the
No,
second affidavit,
additional affidavit.
Lordship.
Additional affidavit you have filed on 13/3/2025,
My lord.
422.
This affidavit, your lordship will consider in the light of the direction passed by this honorable court.
Okay. Yes, we have this affidavit.
They have, my lord, enclosed some documents. Page 427, your lordship will find a communication from the, my lord, Chief Engineer Railways to the government, Assam, 1959. They are following some draft notification.
No, my lord.
These are only draft
Yes,
notifications.
yes. Can you show us, Mr. Borgoto?
Well, Annex 8, that is not a draft notification, my lord. These are the notifications.
The following documents
Page 427.
relating to the land acquisition officer Guwahati duly signed by the Deputy Commissioner Kamrup for acquisition of 170 bighas, 4 kathas, 16 acres of land. Then enclosures your lordship will find a draft notification in triplicate, draft declaration in triplicate,
Thereafter, my lord.
certificate in triplicate, details of boundaries. Since the land is urgently required, you are requested to kindly take immediate action on this, advising this office and the Deputy Commissioner for giving advance possession of land.
My lord, thereafter. Annex 9, my lord. That is the notification. my lord.
And it is there. Notifications are there.
And thereafter, my lord, Annex 11, they have given us advance position of the land also.
Page 430,
420,
430.
430, my lord.
The position of the advanced position.
What are they say, my lord?
And thereafter, my lord.
But one point will arise. The acquisition was mainly for the purpose of the approach road to the Khoraighat Bridge.
My
Now that thing has been accomplished long time back. Are you still in requirement of this land?
My lord, in fact, they are opening a new bridge over Brahmaputra, my lord, as far as my information is there. My lord, then they will be making double line also. In fact, in all the places from Maligaon to Nunmati, my lord, they are clearing the areas, my lord. They are planning to open up new railway lines, my lord.
That is not in the.
That is not there in the affidavit, my lord. But the survey is going on, my lord. They have marked the lands. They are planning to clear it, my lord.
Yes, anything else?
Well, the best approach, as your lordship have said, my lord, let them go to the civil court. If the railway can defend, good, my lord.
Yes, Mr. Roy, you are for whom?
For the lordship, paragraph 8 of our affidavit, lordship. And annexure 1, lordship.
8 of your affidavit means affidavit by?
Deputy Commissioner, lordship.
26.
Can you give the page number?
20, lordship, it is in my, it was 3 to internal page 3.
Your response number?
4.
4, okay, 348. Affidavit in opposition,
Yes, lordship.
348.
Then internal page 3, lordship. That is
300.
page, paragraph 8. This is our step, lordship. And annexure 1 to that affidavit. There's a draft.
348, yes. R4.
Paragraph 8 is relevant.
Yes.
Which para?
Paragraph 8.
Para 8.
Lordship, internal page 3, lordship.
At 350.
Lordship.
Right, please read.
Lordship, that with regard to the averment made in paragraph 8 to 10 of this writ petition, the deponent begs to state that the Deputy Commissioner Kamrup Metropolitan District communication wide letter dated so and so and dated 26/7/2009 to the Principal Secretary to the Government of Assam Revenue and Disaster Management Department, Dispur, Guwahati 6, seeking a view for correction of the land records in favor of the NF Railway /PWD NH in the village Utkar Jalukbari under Moja Jalukbari, erstwhile Ramcharani Moja in Kamrup Metropolitan District. In para 7 of the communication, this is annexure 1, lordship, to that affidavit, lordship. Para 7 of the communication letter, it was stated as per draft records 1957-64, the status of the land covered by DAG number 178 old 30 new with an area of 60 bigger 2 katha 7 lessers was Nishikiraj, half revenue paying state with the clear Nishikiraj boundary symbol printed in the map. During current Guwahati resettlement operation, record has been corrected showing a plot of land measuring 13 bigger 1 katha 11 lessers as Khiraj Miadi Patta, land covered by DAG number 13 co under KP Patta number 109, while the balance land of the part co of DAG number 13 measuring 47 bigger 0 katha 16 lassa has been shown as the railway acquired government land by putting it under a new DAG number 269 reportedly in terms of order of the Deputy Commissioner White so and so dated 28/2/01. Since the entire land measuring 105 bighas so and so of Uttar Jalukbari village covered by DAG number so and so so and so so and so point were acquired for NF railway on payment of LA compensation to recorded pattadars and the land having been acquired by the government land, no patta land whatsoever can exist out of the acquired land measuring 105 bigha of land. The correction of the land record to the effect of creating a patta number so and so containing a part of the acquired government land measuring 13 bighas and so is absolutely incorrect and needs to be cancelled. In response to the letter dated so and so 24/7/2009, Deputy Secretary Government Assam Disaster Management Department, Dispur, Guwahati, gave an approval to correct the land record as per the acquisition case, Railway and PWD NH, observing rules and procedure. Wide letter dated, letter number so and so dated 31/10/2009. Accordingly, Deputy Commissioner Kamrup Metropolitan District directed the settlement on a resettlement operation Uluwari. According, the land record was corrected in the government land.
Now thereafter, Mr. Borkotuki has said that it was again, the conversion was done without notice in 1999.
It was in 10/11/2009 Lordship. It was after that 2009 Lordship.
Now it is under whom? The record?
Railways, Lordship.
Railways.
Railway.
Then what is this letter 10/11 was recorded, corrected to government land means?
According the land was corrected that the excess land Lordship, the annexure Lordship, it will be annexure 3 Lordship.
So this letter which you are referring is 2009.
Lordship.
We are just trying to relate your arguments with Mr. Borkotuki's arguments. He said that 1999, the land of the railways was converted to government land without notice, and thereafter again it was corrected. How do you reconcile this?
Not sure.
What is the meaning of this? What is the implication of this expression government land in the page which you have just read, 351? Converted to corrected to government land.
Annexure 3 Lordship to my affidavit Lordship. This is the letter correction of the.
Annexure 3 is page.
It will be Lordship.
Annexure 3, okay, 359. 359.
Lordship. This is the letter Lordship. In favor of the NF Railway PWD in village so and so so and so. Government letter dated with reference to the, I am requested to effect correction of the land record, case number railway acquisition so and so so and so. Sent here with the papers are being sent to.
To effect correction of records.
If the Lordship comes to page 267 of the writ petition, my lord.
267.
267 the writ petition, it will be clear, my lord. Actually, 1999, my lord, all these 60 bighas of land was converted to Sarkari. Thereafter again, out of that, my lord, 47 bighas were converted to railway land. 13 remains. Thereafter, my lord, in 2009.
Just a minute. Just a minute. 267.
Yeah, man, clear document only.
267. The no remarks. What is there? As per so and so by government of India. Next.
Number 13, my lord. Compare to railway line again. This is not on the challenge.
How many of the petitioners, how many petitioners are there? 37.
37.
What is the land under your position?
Total land, my lord,
8 bighas.
8 bighas.
Around 8 bighas.
My lord.
And this 8 bighas is under this 13 bighas.
Yes. Because in respect of 4 bigha, they had my lord done the case. Land measuring 8 bighas, 1 katha 14 letters. And in respect of the my lord remaining part, there is decay. Out
And
of
this
it,
decree, the subject matter of the decree and this plot of around 8 bigha, it comes under the 13 bigha.
yes. Over 9 or 8.
Have you annexed the judgment of the civil court?
Yes.
Where is it?
Will court, my lord. At
Page
that
286.
railways could not defend it properly, my lord. That's the reason that decree when.
Page 286.
That's the reason the court has also said, unless the decree is set aside, let them be there.
286.
That's not far with this.
It starts at 286.
Yes.
Then they filed an appeal, my lord. Appeal was dismissed for default. Then they tried for restoration, my lord. That was rejected. Against that, my lord, they filed a CRP. That was rejected. All these documents have been annexed, my lord. And your lordship will see the stand of the railways in the judgment, in the decree of the civil court. At different point, different stands are taken. Decree is at 286.
But this decree is of 2001.
Yes. The petitioners did not join matter for some strange reason.
And your writ petition is filed when? 2015? 17?
17.
They were under the belief that they are protected by this decree. That is what they are under.
Till 17 you were under the belief. Too long a belief.
Because my lord, the
17 years.
commissioner issued us a notice.
But is your way to the civil court open now?
And that's why, my lord, unless they issue some notice, my lord. Because they have not issued any notice. The notice was issued by the deputy commissioner way back in, my lord,
See, we are no one to advise you. You wait for your turn till the notice comes. Maybe there'll be a cause of action to go to the civil court. Now, there is absolutely no chance.
That's why, my lord, my submission with your lordship is that, my
Now,
lord.
they have also said that till now notice has not been issued. It was merely on apprehension. We'll refer this background and say that if some action is taken, it is up to you.
My-
We will not say you can approach the civil court now by that will give a wrong message. Cause of action, if any, was in 99. Now in 2025.
No, my
Difficult.
lord, the deputy commissioner's notice was in, my lord, that is also in 2003 in my lord. That is about 2003. Because on representation, my lord, the deputy commissioner gave a hearing. That was in, on, my lord, 21/12/2009. So that will also not really help you to recognize now, my lord.
Okay, we'll think and pass. Adi pass korean. Very good. Okay, we'll consider. We'll reserve the.
My-
Based on the. And.
We cannot remain remedial as
SS Roy, State Council, and A. Bolkotoki for the release. You are also there, madam. P.R. Mohanta. Hey. Pending Council Revenue. Reserve for release. What's up?
well.
Thank you for watching. Yeah, very good. Twenty-three is 4303.
Well, 4303.
Number for the very. Terminate which one number? 431. Four three zero three is your matter. Yes, what is this?
Well, the next one is a Jamabandi Mela. This is a lot the surveyed village Mela.
Page
17 Mela.
17.
Yes, Mela. The English verse translation is page 16 Mela. It's a it's a Basti land Mela. And Mela, the Dag number, Patta numbers allotted. And Mela, in fact, Mela, we had Mela purchased Mela possessory rights. Mela from the Patta number 3 Mela. Konoti Sangma. And my lord, we had obtained our my lord, electricity connections, my lord, holding number, etc. Constructing houses, my lord. Therefore, my lord, our case is that, my lord, these are not forest lands, my lord. And page 62, my lord, is a notice issued, my lord, by the forest department, my lord, saying that we've encroached upon, my lord, forest, Patasil Reserve forest land. Page 62, my lord.
62.
62, my lord. 62 is the translated copy, my lord. 63 is the vernacular one, my lord. And 64, my lord, is another notice. So two petitions before lordship, my lord. They are having, my lord, adjacent, my lord, land, my lord, the same patta. And the notices were served, my lord, alleging my lord, they've entered illegal to reserve for Patasil Reserve Forest land, my lord. And they were asked to voluntarily leave this within 7 days. This of 27.
As per you, this is not forest land.
This is not forest. This is our case.
This is khas land.
Cast them.
That is your case.
That is it.
And Mr.
Lord,
Bhuyan?
exactly, only the number of petitioners is more, my lord, 274 before my lord, my lord. Same plea we have also taken, my lord. And the demolition time period has been given only 7 days, my lord. Notice dated is 20,
No, that aspect will come later. First, you say that it is not forest land.
no, my lord.
So if at all 18 will come in,
Fine.
Talakudin will come in.
Fine.
Yes, Mr. Advocate General?
We have very clear instructions that this is a forest land falling under lordship, this Fota Hill Reserve Forest, which was notified in the year 1966. We have the complete demarcations as well as the map also.
But what about this Jamabandi?
This Jamabandi lordship in the second case, I am not finding second case.
Yeah. This is that page, my lord, 287, my lord.
But without making a demarcation, ultimately it's a question of fact. You may be correct, he may be correct.
Fine.
Notices do not indicate any boundary or anything.
Any boundary, any-
This is a lot, I think.
If it is forest land, our hands are tied. We will not give them any relief.
Lord,
But if it is khas land, then also you have the power to
we have
remove the.
then
but
we will apply different
you do
channel.
different channel.
That
Make
is not
demarcation.
the issue, but it is a open and shut case that this land, this voter right, this some electricity connection papers, then voters list.
No, those
This-
will not make any difference. You rest assured that those are not going to influence this
Yes,
court.
Lordship, that
So
is
what is the most important thing is the Jamabandi. Jamabandi is there. You don't issue a Jamabandi on
let the
forest
matter
land.
come up tomorrow, Lordship. In the meantime, I will verify these Jamabandis, whether they are from that place or some other place.
Okay.
Because otherwise also 7 days period is not
Okay,
over.
okay.
Lord, another thing is that, my lord, this notice has been issued very selectively, my lord. The purpose of annexing the voter list, my lord, to show the selective identification of the persons, my lord. That is a thing, my lord.
See, that is another aspect. But
Fine.
first, our concern is
Whether
what is
forest-
the nature of the land.
My lord.
If it is forest land, if you ask for some time, we may be considerate, we may give you some more time,
Mal.
which we are doing in other cases.
Fine.
But if it is, if it's a
Khas
not khas land, then our orders will be different.
Fine.
And to determine that, your Jamabandi will have a value, which the learned AG is saying that a verification will be done.
Monday itself.
Whether it pertains to the same plot of land or not. Yes, tomorrow.
In fact, the notices do not indicate any plot of land, my lord. It says.
Because forests don't have a this dark number
No,
pata.
the notices have,
The reserve forest.
notices have been issued on the presumption that these are forest land. Therefore, there is no question of demarcating or dark number. There is no dark number as such. So tomorrow.
Tomorrow.
Third. 3. M. Datta. Learned Counsel. As well as 3. A.R. Bhuya. Learned Counsel for the petitioners in these 2 cases. Para. The primary. In 2 cases wherein the petitioners have challenged the move to evict them from the land under their possession. Full stop. The primary contention is that though the eviction has been sought to be done on the presumption that the land in question is forest land, it is the contention of the petitioner that such land is not forest land. And to support the said contention, the Jamabandi, few of the Jamabandis have also been annexed to the petition. Para. The learned AG has, however, contended that there are clear instructions that the land in question is forest land. Full stop. In any case, comma, he prays for a day's time to verify the aspect of the Jamabandi. Full stop. List for motion tomorrow.
Deeply obliged.
Deeply obliged.
Like. May I plead? Your
Yes,
Lordship? Lordship, I may be allowed to withdraw this petition. Since the money laundering case has been pending, before the special.
your SO. What is
M.
your
Deca,
name?
Lordship.
Huh?
M. Deca, Lordship.
You're on record, yes.
Yes, Lordship.
Who is for the ED? Enforcement Directorate. Any CGC? Mr. Roy? Does he appear for the ED?
The Medi, SK Medi. Mr.
SK made his name was
Name was
reflected.
shown in that.
Is he there in the court today? We can reflect his name. Madam Hazarika, is he there? Mr. Okay, we'll record his name. Sri M. Deca, learned counsel for the petitioner, has submitted that he has instructions not to press this writ petition. Sarah? Sri S. K. Medhi, learned counsel for the enforcement directorate is present. Sarah? Writ petition is dismissed as not present.
Liberty may be given. Oblige.
Yes, next.
Oblige.
Item 5, my lordship, I need some time. My lord, the instruction I have received, my lord, it is not up to date, lordship.
21 matter, why should we give time?
My lord, that this is regarding, my lord, that T-Patta land. So she is seeking NOC. My lord, you have to take an approval from the government lordship. My lord, that whether the.
Have you seen the last order of 9?
Lordship, I have seen, lordship, I have seen. I
The
have
matter is
received one.
pending since 2021, no affidavit filed considering the assurance given by Sri Hendik. The matter stands adjourned. Affidavit to be filed on or before 18/7/2025.
Lordship,
And we are on 31st of July 2025.
instruction I have received, but it is not up to date, lordship. Lordship, last line, last para, lordship, kindly peruse. But the circle officer, that proposal was sent to the deputy commissioner. Whether the deputy commissioner interested
If the respondents are not serious to defend their case, they have to face the consequences.
that is true. Lordship. Lordship, give
No,
me a
we
last
are-
chance, lordship.
Yes, last chance.
Last not.
Do this court wide order dated 9/6/2025 had given an opportunity to the state to file the affidavit, Sri J. Handik, learned state council has submitted that certain instructions have been received on 17/7/2025, which however are not
Last para, lordship.
complete. Full stop. He has submitted that further instructions have been sought for. Para? The learned state council accordingly prays for another opportunity. Para? Considering the background, a final opportunity of further 2 weeks is granted to the state to obtain instructions / file affidavit in opposition. Para, list after 2 weeks.
Oblige.
Obligations. May I please, your lordship, my lord, this petition is filed mainly, lordship, on the grounds of lordship, non-disbursement of the direct compensation and less assessment of the less valuation of the lordship land compensation, lordship.
May I please?
So now, lordship, after filing of this writ petition, lordship, there is a came into notice, lordship, that there is a title suit filed by some person, lordship, and accordingly, lordship, on 7/1/2025, lordship, 50% of the direct compensation that was paid to me as lordship, and 50% that was transferred to the lordship landed court below, lordship. So we will, Lordship, file appropriate application before the Lordship, appropriate.
Civil
for-
court.
Yes, Lordship, civil court. And second prayer, Lordship, regarding second prayer, Lordship, that is less valuation, Lordship. May please to submit, Lordship, that as per 3G5, Lordship, let an arbitrator may be appointed, Lordship.
You apply for
We
Announcement.
have already filed, Lordship. According to, again, we will file, Lordship.
if they file you have appointed, they are bound to take action in accordance with law.
Yes, Lordship, that.
Part 3 NH Borbia,
Yes.
Learned Counsel for the petitioners. Also heard the Arboro
Lordship, for 5, 6 and 7.
for
5, 6 and 7.
6 and 7 have been implemented.
Immediate, your Lordship.
Also heard 3, first you write Ministry of Railways,
Lordship,
you'll take.
Lordship.
SS Roy CGC for 1. Revenue Department, yes. Revenue gossiping. Revenue found gossiping. Gossiping with which department? We don't see the department. Department is hiding.
Sorry.
Uh,
7.
Hazarika for 2. 3 and 4. You for J. Handik for 3 and 4. And 5, 6.
5, 6 and 7, Lordship.
5, 6 Arbor. Para. Considering the facts and circumstances and as agreed to by the learned counsel for the parties, the present petition is taken up for disposal at the admission stage itself. Full stop. Para. The petitioners, who are 2 in numbers, claim to be the registered patladar. Please have your seat. Patladar of a plot of land measuring 12 katha, 3 chataks under dag numbers 15 and 16 of second RS Patta of 7 of second RS Patta number 7 of Revenue Village Rangpur, Part 2, Pargona, Barakpar in the district of Kachar. Full stop. It is claimed that the aforesaid land was purchased by the petitioners by a registered sale deed dated 27/4/1988. And since the date of their purchase, they are in possession of the land. Full stop. The petitioners had made constructions over the said plot of land by following the norms. Full stop. However, the land along with the residential building came under the acquisition process for expansion of the adjoining national highway under the Bharat Mala project, which was initiated, and in this connection, notification was published in the local daily newspaper, inverted comma, the Dainik Juga Sankha. Full stop. Though the compensation amount was determined and sanctioned in the names of the petitioners, the grievance of the petitioners is with regard to the compensation for the Jirat compensation. Full stop. Para. 3. Borbia, the learned counsel, has submitted that such compensation is a legal entitlement, and in this regard, he has also relied upon the judgment of the Honorable Supreme Court in the case of so and so reported in 2024,
24.
7 SCR
Yes, Lord, 7 SCR
443. Para. The learned counsel for the petitioners have, however, informed this court that as per instructions received
That on 7/1/2025, an order was passed by the Kala Lordship.
on 7/1/2025, the designated authority, that is i.e. the CALA, had passed an order. What?
That as per Lordship in title suit case number 107/2024, that 50% amount of the Jirat compensation that was sent to the civil court and 50% released to me, as Lord.
Has, however, that that Skala has issued a communication dated 7/1/2025, as per which 50% of the Jirat compensation has been deposited in the civil court in connection with title suit number
107/2024.
107 of 2024 in which court?
In the Civil Judge Senior Division number 1, Kachar Center.
Civil court, no, civil judge senior division on Kachar. And the rest of 50% have been paid to the petitioners.
Petition.
Full stop. He accordingly submits that appropriate directions may be issued with an observation that the petitioners can approach the said civil court and also on the aspect of filing an application for enhancement of the Jirat. Full stop. Para. 3.
Lordship, this is not for enhancement of Jirat, Lordship.
No, the second,
land compensation.
second aspect. Oh, this is for land compensation. For Jirat?
Jirat, we have no complaint, Lordship. Only land compensation that was
But
less
your-
valuation for.
But your initial grievance was it for Jirat?
Jirat as well as less valuation of the land compensation.
What about the Jirat?
Jirat is structural compensation.
No, no. Now, are you, is there any grievance?
No grievance, Lord.
Then we have to record that. Sri Borbia, the learned council has submitted that so far as the claim for Jirat is concerned, there is no grievance as such. The learned council for the respondents have submitted that as per the, what is the name of the act? National Highways?
National Highway Act
National Highway Act
1956.
1956. There are appropriate provisions
Under
for
section
seeking
3G 5.
seeking enhancement. And in this regard, reliance has been put on section 5,
3G5.
3G5
Within bracket
Of
5.
NH Act 1956.
of the said act. Full stop. Para. After considering the rival submission, the instant writ petition is disposed of by giving liberty to the petitioners to approach the appropriate civil court in the pending title suit and further to file appropriate application for enhancement under the provisions of law aforesaid, if so advised. Full stop. It is needless to state that if such an application is filed, the same is required to be considered strictly in accordance with law.
Lordship, that regarding land compensation, enhancement of land compensation.
Enhancement of land compensation.
Obliged, Your Lordship.
Enhancement of land compensation. Yes, disposed of. I thought what is dispose of this? I do dispose of what is again? What compulsion? Implement see. That is the repetition has I had to first things. Actually, are passing an interim and dispose. Interim, implement. Highest and disposing of the in view of the final orders passed. No separate order is called for and accordingly same is disposed of. Yes, next.
May please, your Lordship. Lordship, I was directed by the last order to take instruction. Lordship, may kindly peruse the last order, my lord.
Yes. You
My
have got
lord,
the instruction.
Yes, my lord. Order dated 22/7/2025. My lord, a submission was made by the petitioner side, but that the already evicted petitioners are called by the District Commissioner Kamrup Metro, and it is the instruction that there may be a scope for settlement of some alternative land to the petitioners. So they said that, my lord, they were called by the District Commissioner Kamrup Metro. I have taken categorical instruction, no such calling was there, man. Nothing. It is absolutely a misleading submission.
My lord, I have been instructed by the petitioners, my lord. My lord, there was a meeting, now where that meeting was held, my lord?
No meeting.
That, my lord, instruction I do not have. If my lord wants, my lord, I can file an affidavit. to
Not
that effect.
required.
My lord.
We will not say prolong the matter because of these issues.
My lord.
Yes.
We'll hear the matter.
My lord, may I pray, my lord, that this can be fixed on coming Tuesday, my lord.
Tuesday, is it okay for you?
My lord.
Okay.
The
Part-
pleadings are complete, my lord. We have-
Part 3A are we are learned counsel for the petitioners. As well as we are Borpujari learned standing counsel, revenue department, full stop para. Sri Borpujari, the learned standing counsel has submitted that on the last occasion, though a statement was made that the petitioners were called by the district commissioner and there was a scope of settlement, comma. Upon instructions, he has submitted that there was no such move at all. Para, be that as it may, list these cases for admission on Tuesday. Date.
my lord, if I may pray, my lord, since the pleadings are complete, my lord, it can be taken up for final disposal, my lord.
Let us see Tuesday for admission, we are saying.
My lord,
My lord, there is an.
What is the subject matter?
my lord, subject matter is, my lord, eviction from that tribal belt area in Sonapur.
Okay, interim order passed earlier to continue till the next date of listing.
My lord.
In terms of, my lord, Salakuddin, my lord, all the exercise have been taken care.
Yes, you
Yes.
satisfy the court.
On merit, my lord. I'm so grateful.
You come prepared. You said that Salakuddin directions have been fulfilled, you come prepared.
My lord. Obliged.
Mr. Borua is waiting since long, which matter? Then, next matter.
Yes, Monday.
Okay.
Pleasure.
So the kindly see the order dated 10/6/2025. The matter regarding my lord establishing a brick lane.
My pleasure, Honor, even a pleasure, Lordship. Lordship, Mr. BP Bora, his item is going on court number 10, Lordship, item 11.
Is for whom?
For respondent number 12. Your
Who is
Honor.
12?
Respondent number, private respondent number 12. Lord,
You have the brick clean.
Yes, Lordship.
He is objecting.
Yes, Lordship. Lordship, basically have been instructed to just pass over the matter for time being, your Lordship. I'm not-
Lordship, kindly see the order dated 10/6/2005.
No, let him come. Let
Yes,
Mr.
yes,
Bora
Lordship.
come.
Only after some time, Lordship, the matter will end, he will directly come.
What is your case, Mr. Borua?
It is my lord, they established the brick lane in the agricultural land by violating the.
Who are you?
I mean, we have the, my agriculture is my lord, we are in the land, my lord, that they're going to establish. My lord.
Now this land is belonging to whom?
It doesn't, no, that land is belonging to my lord, them, my lord, but it is in the established in the eco-sensitive zone. But the Supreme Court decision is there, my lord, till the finalization of the eco-sensitive zone, my lord, 10 kilometer radius should be.
Eco-sensitive in the sense, what is there nearby?
Pobitora,
Pobitora.
my lord. That 10 kilometer there should be no, because.
When did you last visit Pobitora?
My lord,
When did you last visit Pobitora?
last visit, my lord, I think 2025.
10 years back. 25?
25, January, maybe January.
You went for a picnic.
Yes.
You never invited us. We could have joined you.
Yes, provided we also accompanied us.
Okay. It's an eco-sensitive zone.
Eco-sensitive, my lord. The
And-
Supreme Court decision is there, my lord, till the finalization of eco-sensitive zone, my lord.
But how are you having agricultural land in eco-sensitive zone?
Because we going to establish.
I must speak to him, not to you.
But there is a division plan decision is there, my lord. If going, permission be given, whether they affect the adjacent land, my lord. But they are silent, my lord. That political.
It has already been established.
No, they established, my lord. They established since 2012. For 2000, they cannot run. But only for this year, my lord, they run, my lord. But 10 years, 13 years litigation is going
But
on.
they will be supplying bricks to you.
Article nowadays, brickly, my lord, the brick has gone, my lord. The slab has, the question of slab has come now. The construction of building slab has been used nowadays.
He's
Very rarely use the brick.
Respondent number 12 is slightly old fashioned. He still allows to produce bricks. There are many persons.
They produce, my lord, but they affect the land, my lord. But their division bench decision is there. They said, my lord, that judgment says, my lord, if the bricklaying is established, my lord, whether it will affect their entire adjacent land. The pollution control board, they have given the permission, but they silent. Impugn order, I challenge them on this ground, my lord, first, but they silent.
Yes, pollution. For no objection, what did you do? Did you make a due diligence before giving the NOC if it is an eco-sensitive zone?
But Lordship, if your Lordship goes to the case, this is the same round of litigations which is rolling one after another. Once they come to the court gives an order, again the pollution gives an the deputy commissioner gives an NOC, then that is being challenged by the other party. Again, they process the court, again, court comes and intervenes the matter. So it has been rolling on for years after years. But the same issue is being debated now and then.
That will raise by the private estate.
Now,
That's not
in
by
fact,
pollution.
as regard the eco-sensitive zone, that is to be declared by the forest state government. And for that matter, that radius has been earmarked. So now, as regard pollution, we have filed a counter affidavit, which is not on record. Today only I have filed it. And government was also supposed to.
Oh, you have filed
I have filed it,
affidavit.
but it is
Oh, then we'll have when did you file? Today?
Today.
Have you served on Mr. Barua?
No,
My clerk.
no, I don't see.
Yes, it will be served upon you and we'll have this on Wednesday next. Is it okay?
Wait, Thursday, my lord.
Thursday, okay, Thursday, if you say Thursday. Okay. I heard Sri R. Barua, learned counsel for the petition, has also heard Sri I. Bothakur, learned standing counsel forest, Sri S. Barua, learned standing counsel PCB, and Sri J. Hendik, learned the state counsel para. Sri, your name?
H. Mozumdar, Your Lordship.
Sri H. Mozumdar is present for the respondent 12. Para. Sri S. Barua, the learned standing counsel PCB, has informed this court that an affidavit in opposition has been filed today, which however is not tagged with the records. Para. List this case on Thursday next date, along with the affidavit of the Pollution Control Board. Is there any interim order? No.
No. That is whatever they are lagging the matter. They know it order, my lord.
Okay, next. Mr. Hussain,
May I please, Lord. My lord, in this case,
PWD,
also the revenue authorities, there was a direction, all of them to file affidavit.
affidavit not filed.
Not filed.
What is the cause of action? What is the cause of action? Why have you come to the court?
Lordship, the PWD department is constructing a RCC bridge over my patta land. And for that, I am not been given any notice, nor my land is acquisition, nor.
Where is your
I
land?
am
Which
given-
place?
Tarangapur, Lordship, Gwalpara.
Yes, public works as well as. Which are the concerned departments? Public works
Public
and
works,
and
And revenue authorities are.
revenue. Bhattacharya.
Yeah, you have to get instruction, my lord.
What is the status now?
Lordship, the machineries are placed on the seal, Lordship. Not work has started, Lordship.
What documents have you annexed to the petition
Lordship.
to prima facie show that it is Patta land?
Yes, Lordship. I have.
Where I was comment for this, I want to bring it by way of one affidavit.
What is it?
Lordship, my lord.
So,
Joint verification has been carried out regarding that. That.
Joint verification carried out. Now, has the land been acquired? No, see, he is not against the construction per se. He is only saying that you have not initiated an acquisition proceeding.
That Myadipatra land is adjacent to the that side.
Which side?
Beside the lordship, the border side of the road lordship.
What is the document you have annexed to
Lordship,
prime
I can
facie show
come
that
to
this
page
is
13.
Patta land, this is Patta land?
Page 13 lordship.
313.
Yes.
Yes.
This is Jamabandi Kobi lordship.
Where is your Patta?
Patta number is there. Patta number 24 new. Dag number 144, 145.
Where do you find?
Lordship, kindly see. Middle portion of my page 13 lordship.
When did you purchase this land?
That is there.
Found the required land for which are available there.
Okay, you file the affidavit then, okay? But whatever you do, it has to be in accordance with law. Okay.
Yeah.
The last occasion, you were already granted time to file affidavit.
Yes, lordship.
And who was for PWD? PWD, who's there normally? B. Chaudhary, B. Gogoi, S. Sharma.
The Nath also.
D. Nath, yes.
(26)5 order.
Names of PWD council reflected or not? Yes, reflected. Mr. B. Chaudhary's name is there. Why isn't he not in the court? Okay, heard Sri M. I. Hussain learned counsel for the petitioner. Para. Though time was granted on the last occasion to the respondents to file affidavit, comma, such affidavit has not been filed. Para. Sri J. Hendik learned counsel has submitted that certain instructions have been received and he would file an affidavit. Put the para. On request, list this case after 3 weeks to enable the respondents to file affidavit. Yes, next.
Yeah,
Yes, you have got a report.
The electrical inspector, the government should have to file.
Has it been annexed here? No.
No, it's the report has not come.
No, you are not aware of any such report.
Report.
Have you done the inquiry?
Next the police report, my lord.
Not on police report.
Yes, yes.
Report of the senior electrical
My lord,
inspector.
yes, my.
The first time of the notice. Sorry.
Okay, you get the report, Mr. Andy? Get the report. Heard Sri T. Sheikh, learned counsel for the petitioner, who has approached this court with a prayer for compensation for the death of her husband on the allegation of electrocution, with the allegation that such death is a result of electrocution. Para. To ascertain, to adjudicate the issue, the report of the senior electrical inspector who has been made party respondent number 3 would be required. Para. Sri J. Hendik learned state council prays for and is granted 3 weeks time to obtain instructions on the aforesaid aspect. Sri B. Chaudhary Learned, Standing Council APSC is, APDCL is present. Okay. 3 weeks.
My lord.
And 14 lordships, I have received one instruction that I want to bring it in record process.
Contempt matter. What is it?
No, my lord, contempt, I didn't, my lord, not whether the notice has.
Notice has not been issued, your lordship, in the contempt.
Not been.
Not issued.
Not
Okay.
issued, your lordship.
And in item 14 lordships,
But kindly peruse the last order, your lordship.
We have seen.
the last order, some instruction was asked me to, my lord, that produce this thing. This instruction I have received.
Okay. So can we take up the matter today?
Lordship, I want to bring this one instruction in the by way of an affidavit.
You will file in the affidavit in the writ petition.
Lordship.
Okay. Sri J. Hendrik Learned State Council submits that he has received certain instructions which he would like to put on record by way of an affidavit. Full stop. He accordingly prays for and is granted 3 weeks' time
Lordship,
to file the said affidavit.
lordship, a shorter time, my lord.
Yes, can you do it before 3 weeks?
I will try, Lordship, my lord, that
My lord, the problem is the encroachment is still going on, lordship. There is an interim order.
there is no, nothing,
How
nothing.
come
has been done.
we'll put a date?
Lordship,
So you list on, since urgency has been expressed, list this case on today's
31.
1, 2, on 19th.
Lordships.
Okay,
Thank you.
19th. Yes, Dr. Saraf, Mr. Sayala, which matters?
Village, your lordship.
Hearing matters. Orders আছে না?
May I please? My lord, the order passed by this honorable court has been complied with subsequently by the respondent authorities, my lord.
Yes, what was this case about?
Yes.
Lordship,
What?
Have a seat, let him, what was the case about?
My lord. Now, my lord, in a contempt case, lordship will find the order passed by this honorable court at page
14.
My lord.
Is it 18/12/2023?
Yes.
What was the order?
Property part, my lord, para 11. In the above view of the matter, the part of the impugned order whereby the respondent number 3, the Register of Cooperative Societies Assam, has directed to appoint a new secretary of the society temporarily in place of the petitioner and has allowed the next board of directors to take the decision on the matter of appointment of a new secretary shall remain suspended till the returnable date.
Who was the petitioner? What was his grievance in the writ petition?
Petitioner was the Milord secretary who was removed by the Milord respondent authorities. And somebody was appointed as in charge. So he challenged this Milord removal order before this honorable court.
Okay, not to appoint new secretary, that was the
Yes,
order.
that was the order. And that order also, Milord, we have annexed here. Lordship will find at page 9 the order impugned in the writ petition.
Page 9, yes.
Yes, that was the order, Milord. Last paragraph, Milord. the operative part, my lord. In view of the above, in consideration of the aspect, Sri so-and-so, Registrar of so-and-so is of the opinion that since the board of directors of the society was dissolved, hence the officer on management of the society is hereby asked to appoint a new secretary of the society temporarily in place of so-and-so, who is hereby suspended to hold the annual general meeting, election of the so-and-so society as soon as possible. Regarding the appointment of the permanent secretary of the Paschim Mondia SS Limited, the next BOD will take decision on the matter as per the Assam Cooperative Societies Act 2007 and prescribed bylaws and so.
Yes, we have
That was
seen.
the input order.
Okay.
Now, Lordship, kindly see our affidavit in reply. The Lordship will find page 37. Page 37, my lord.
Yes.
And operative part, Lordship will find page 38. That is, my lord, order dated 17/2/2024. The notice was issued in the contempt petition.
Why have you enclosed the order of the same proceeding?
My lord.
It is there in the record.
Yes, yes, record. My lord,
Nonetheless, what do you want to show from this order?
to show that, my lord, after getting the notice from the contempt, my lord, petition, they have, my lord, complied the order that your lordship will find at page 32 in the affidavit filed by the respondent number 3. In contempt, my lord, notice was issued on 17/2. And they have complied the order, my lord, on 23/2/2024, page 32 in the affidavit filed with the respondent number 3, my lord.
Yes.
Page 32, Lord, you have seen. Page 32 is the compliance order by the respondent number 5. That was.
Yes, something had, we had
Yes,
noticed
Lordship,
something.
Lordship may kindly have a look. Lordship order today 24/6/2025. My lord order, may I read, my lord?
Just a minute. You're for whom, madam?
Free, my lord. The register,
Art free.
Lordship. We have filed affidavit, my lord.
Which order you want to?
Lordship 24/6/2025.
Yes.
Lordship, her so and so, learned counsel petitioner who has submitted that the petition has been become infructuous. On the other hand, MSMD Board Learned Counsel appearing for the respondent number 3 has submitted that the present proceeding was instituted by grossly abusing the process of the court. By drawing the attention of this court to the affidavit in opposition filed by the respondent number 3 on 19/3/2024, she has submitted that the petitioner had himself issued a communication dated 30/1/2024, whereby he had informed about his ill health and to give the assignment of the post of the secretary to someone else till he's become fit. Thereafter, a resolution was taken by the concerned Samabay Committee subsequently on 23/2/2024, when the petitioner had reported his fitness, he was allowed to function as secretary. She has also informed that the connected petition being such has been disposed of and interim order has already been vacated. So this honorable court has directed the petitioner submitted that the letter was extracted from his client under a threat. However, till now, no affidavit has been filed in this regard. The proceeding in the court are sacrosanct in nature, wherein it is the paramount duty of this litigant to approach the clean hand. It is also the duty of the court to be vigilant on this said aspect. In this interest of justice, 3 weeks time granted to the petitioner to file affidavit reply. Then in my affidavit, the petitioner has filed a reply, my lord. In paragraph 3 of his reply, lordship may kindly have a look what he has written. He has stated that someone has fraudulently threatening, given under threat, he has given the signature in a blank paper in paragraph number 3. Lordship will find at line 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10th line from bottom.
Which paragraph, which affidavit in reply?
Reply, page 34, my lord. Paragraph 3, lordship has got it, my lord.
Please read.
The relevant portion of whole paragraph I am reading, my lord.
No, which is the relevant portion?
Lordship,
Read the relevant portion, the explicit in an order.
hand over the charge to the deponent, and accordingly the deponent attended the meeting, where again on back letter dated 31/24, the signature of the deponent was taken in the blank paper by threatening by the respondent number 6 and the some Bilal Hussain. Lordship, he says they have given him threatening, so he signed a blank paper. Then my lord may kindly have a look my affidavit, page 31. He has stated someone has taken blank signature in a blank paper. Then page 31 of my affidavit.
Vernacular.
Yes, my lord, vernacular. The signature, lordship will see Lokman Hussain is the petitioner here, and the application who is written by the Lokman Hussain, the handwriting is similar, so there is nothing, my lord. Lordship may pass appropriate order.
Non-provoked যদিও মোৰ শাৰীৰিক অসুস্থতাৰ বাবে মই অসুবিধা হ'ব এই বৰ্তমানলৈকে কমিটি কৰি আছে। How have you explained 31, Mr. Mondal?
Hello.
How have you explained page 31?
Yes, 31. Yes, that has been explained, clarified in para 3 of our affidavit.
Let us see the reply affidavit.
Yes. Para 3, madam.
Yes.
That with regard to the statement made in paragraph 3 and 4 of the affidavit in opposition, the deponent denied the same and begs to self. Despite the order dated 18/12/2023, no action was taken to hand over the charge to the petitioner till 17/2/2024. While the notice was issued by the Honorable Court in contempt case number so and so, after getting the notice, the respondent number 6 and on Vilayat Hussain Secretary additional charge Paschim Mondia GPSS Limited held a backdated meeting dated 31/1/2024 to hand over the charge to the deponent, and accordingly the deponent attended the meeting, where again on backdated 31/31/2024, the signature of the deponent was taken in blank paper by threatening the respondent number 6 and the Vilayat Hussain Secretary additional charge Mandia GPSS to comply the order dated 18/12/2023 passed in WBC number so and so, later dated so and so, issued by the respondent number 5.
Yes, how have you verified this serious allegations of paragraph 3?
Yes.
How have you verified? You are making very serious allegations.
Yes.
Paragraph 3, the contents have been verified as per what? Finally come to the affidavit portion, the verification part.
My lord. Paragraph 3.
Paragraph 3.
Yes.
Allegations, can it be true to records? You are making a serious allegation of facts. See, contempt matter, we take it very seriously. Now, if you manufacture a contempt, then we'll take it more seriously. You cannot take this system for a ride.
And subsequently, my lord, that said petition has been dismissed. That has been annexed, my lord, lordship will find at page 37.
We are not on the dismissal part.
Yes.
We are neither on the vacation of the interim order. We are on the part of your approaching this court with an allegation of contempt by knowing fully well that there was no willful and deliberate disobedience.
Now, since
And paragraph 3, you have verified as per
yes.
records.
Now, since no response has been filed by the respondent number 4, 5, and 6 till date
Where?
in the proceeding,
Which proceeding?
the contempt proceeding.
Why is it required?
Now, allegation is made against
Now,
the
will we
respondent.
harass somebody on a matter of this nature?
Now, allegation is made against the respondent number 6.
Are you aware that issuing notice in a contempt is not, we do it as a matter of routine? The moment a notice is received in a contempt petition, contempt or what is the consequence? Punishment? Have a seat. You have to pay cost. We have indicated on the last occasion itself. Heard? Oh, no. The present case is yet another example where the process of this court has been abused by taking resort of the Contempt of Courts Act. Full stop. The provisions of the aforesaid act has penal consequences, and therefore it is the bounden duty of the applicant approaching this court to make such approach bona fide and with clean hands. Full stop para. To appreciate the background, it would be necessary to put on record the brief facts leading to filing of this case. Full stop. Para. The petitioner had initially filed a writ petition being WPC 7336 of 2023 against an order dated 14/11/2023, whereby the petitioner was removed from the post of secretary of the Paschim Mandia SS Limited with a direction to appoint another secretary. Full stop. This court had passed an order dated 18/12/2023 whereby notice was issued and an interim order was passed staying the impugned order dated 14/11/2023. Full stop. For ready reference, the operative part of the order containing the interim direction is extracted herein below. Paragraph 11, page 16. Para. The contempt petition was thereafter filed on 13/2/2024, alleging that the aforesaid order dated 18/12/2023 was willfully and deliberately violated. Full stop. Para. This court wide order dated 17/2/2024 had issued notice to the respondent number 3 and 6. Full stop. It may be noted that the learned counsel had made several other incumbents, respondents, and it was submitted that the notice could be restricted to respondent numbers 3 and 6. Full stop. Para. The respondent number 3 had appeared and filed affidavit in which some startling revelation has been made. Full stop. It has been stated in the affidavit, which is supported by the relevant documents, that on 30/1/2024, the petitioner had given a letter informing his ill health and to give the assignment of and to give the responsibility to somebody else till he becomes fit. Full stop. Thereafter, on 23/2/2024, the petitioner had informed his fitness and the order giving him the responsibility was accordingly issued. Full stop. Para. I have heard Sri M.U. Mondal, learned counsel for the petitioner, as well as Miss M.D. Bora, learned counsel for the respondent number 3. Full stop. Para. Sri Mondal, the learned counsel, had at the outset submitted that by passing of the order dated 23/2/2024, by which the petitioner was allowed to function as secretary, the order in question dated 18/12/2023 stood complied with, and the matter can be closed. Full stop. Para. Though at the first brush, the submissions made appear to be acceptable, the conduct of the petitioner in filing the contempt case itself, knowing fully well of the letter dated 30/1/2024 issued by him, is something which is to be looked into seriously. Full stop. As noted above, the contempt petition was filed on 13/2/2024, and the letter informing ill health of the petitioner was issued by him on 30/1/2024, wherein he had also informed that as and when he would be fit, the responsibility can be given to him, which was accordingly done on 23/2/2024. Para. Sri Mondal, the learned counsel for the petitioner, has submitted that as regards the letter dated 30/1/2024, the same has been explained in the affidavit in reply filed on 28/7/2025, and in this regard, the averments made in paragraph 3 have been pressed into service. Full stop. The said averment reads as follows. Para. However, a perusal of the contents of paragraph 5, whereby the verification has been made, it is found that the said averments have not been verified as being matters of knowledge and verified as being matters of records. Full stop. Para. Miss Bora, the learned counsel for respondent number 3, has drawn the attention of this court to the letter dated 30/1/2024 issued by the petitioner, and has contended that even otherwise, the allegation that the letter was extracted from him by force or being backdated clearly appears to be a misleading submission, full stop. This court has also seen that while the learned counsel has made a submission as recorded in the order dated 24/6/2025 that the letter was extracted from his client under a threat, comma, in the reply affidavit filed on 28 July 2025, as mentioned above, comma, the allegation is that the letter was prepared on a backdate, full stop. Para. Apart from the inconsistency in trying to make an explanation regarding the letter dated 31/2024, this court is of the clear opinion that there was no reason at all to come to a conclusion that there was any defiance of the order dated 18/12/2023, full stop. This court has also found that immediately on information given by the petitioner regarding his fitness, the order dated 23/2/2024 was passed by giving him the responsibility of the post of secretary, full stop. This court has also noticed that the writ petition itself was dismissed and the interim order was vacated, full stop. But however, without even going to the aspect of dismissal and vacation of the interim order on a subsequent date, comma, the very conduct of the petitioner to resort to the Contempt of Courts Act, which is apparently a tactic to harass the government official, is deprecated by this court, full stop. Para. Accordingly, while this contempt petition is closed, comma, this court imposes a cost of rupees 10,000 upon the petitioner to be paid to the lawyers so and so.
I'm so deeply obliged, my lord.
Advise your client not to do the kind of things.
I'll.
You are an officer of the court, it's your responsibility. And how have you verified? You might have been correct, yes, threatening is there. How have you verified the affidavit?
Now, my lord, what has been inspected to us, we have put it on.
How have you verified? That is your part.
Yes, that is true, my lord, but
The
letter,
verification is your part. Verification is not as part of the client.
yes, that's true, but the letter is a, my lord, matter of record, my lord.
That letter is a matter of record, but the allegation that that letter was issued by threat, can it be
Yes,
a matter
yes.
of record?
That's true, my lord. Yes, statement, my lord.
So deeply obliged.
Obliged, sir.
Yes, next.
May it please your lordship. Lordship, the son of the petitioner, lordship, he died in an unnatural death while he was in judicial custody at District Jail, Golaghat, in connection
What
with
was the age of the deceased?
30 years.
13. 13.
30. And he was arrested in a case which was registered under section 376/420 IPC. And he died in an unnatural death.
While in police custody or judicial custody?
Judicial custody. While he was in District Jail, Golaghat, my lord. And my lord, deceased was completely fit and have not suffered from any kind of ailment, my lord. And thereafter, my lord, The postmortem
He
examination.
was a convict or he was accused?
UTP, my lord.
Huh?
Under trial prisoner.
You accused.
Accused, my lord. In that particular case, when he was arrested and he was behind the bar, at that time, my lord, the case was under investigation stage.
What were the sections involved?
376,
Okay.
420, my lord. So, my lord, after his death, my lord, the postmortem.
When did he pass away? When was it?
He
Date of
died
death?
on 31/7/2012.
13,
31. 31/07.
2012.
2012. As per, my lord, the report, my lord, of the jail authority, my lord, at 12:35 AM.
Midnight.
Midnight.
PM? PM? Postmortem?
Postmortem was conducted, my lord, on the same day, my lord, that is on 31.
What is the finding?
My lord, that your lordship will find at page number 31, my lord. Page number 31, my lord, I have annexed the, my lord, postmortem report, my lord.
31.
31 of the repetition.
Yes.
My lord, there, lordship will kindly see, my lord, the right hand side of the, my lord, postmortem report, my lord, more detailed description of injury or disease. Lordship got it?
Yes, yes.
My lord, all the changes are antemortem in nature, and the postmortem examination done after 24 to 36 hours of incident. The finding of cardiomyopathy along with coronary artery rupture can lead to death of a person. However, this is important. However, to rule out any poisoning cause, the following viscera are sent for forensic examination. Content number 1, so and so whole stomach and its contents with a parts of liver. Container number 2, right kidney. My lord, my lord, the petitioner is the, my lord, the father of the, my lord, deceased, my lord. My lord, he as an outsider, my lord, we don't know, my lord, how the he was died.
Viscera report has come.
My lord, that is the main issue, my lord. Here, my lord, that was not, my lord, conducted, my lord. Even it was not sent for FSL examination.
No, it was sent, it was preserved for FSL.
Yes.
Whole
My lord,
stomach.
my lord, that is, my lord, my lord, this, my lord, this was not even sent for forensic science laboratory for examination, my lord, by the officer who had, my lord, doing the investigation, my lord. That is apparent from the report and the affidavit which have been filed, and also, my lord, from the inquiry which was conducted by, my lord, District Judge Golaghat.
There is an inquiry by the district judge.
Very belatedly, my lord.
In this matter.
In this matter.
Pursuant to the order of this court.
Yes, yes.
What is the finding?
That was, my lord, lordship will find that, my lord.
Judicial inquiry done.
Judicial inquiry done. And in the judicial inquiry, my lord, it has been observed, my lord, that this, my lord, the kidney and all, my lord, viscera was handed over by the doctor who has conducted the postmortem to the police official, and the constable who has received it, he has handed over to the, my lord, to the investigating officer. And from the case diary and from the report, from the evidence of, my lord, the officer in search, he deposed before the district judge that from the case diary it shows that the same was not forwarded for forensic science.
No, was there any injury on the external injury? No.
No.
But there was no any such external injury as per this, my lord, the postmortem, my lord. So, my lord, my submission is this, my lord, it may be a case of poisoning, my lord. I don't know, my lord. But, my lord, as because my son was an UTP, my lord, it does not mean that, my lord, the viscera would not be sent for FSL, my lord. But here, my lord, the police, it may be, my lord, the investigating officer just to protect the jail authorities, my lord. It may be.
That will be a slightly speculative. If the judicial inquiry was not done till now, matter would have been different. Now judicial inquiry has been done. The only point where you have a scope to argue is regarding the poisoning part.
Yes.
But we are immediately concerned with whether there were any external injuries found on the body of the deceased, which should have led us to look into that in that line. Poisoning aspect may be there, may not be there. But if you are alleging poisoning, first you have to allege there has to be sufficient grounds. How many days you are in the judicial custody?
But I think, my lord, not more than 14 to 20 days, my lord.
And judicial custody, as you know, is much different from police custody.
The very day, my lord,
Yes.
when the person was died, my lord, on the very date, my lord, on the 38th, my lord, he was even produced before the, my lord, CGM Golaghat, my lord. And then he was again, my lord, back to the, my lord, judicial custody, my lord. And in that period, my lord, some DNA testing and all, that was also, my lord, police made a prayer for DNA examination. And to that effect, my lord, some petitions were filed before the learned CGM court. And
What is
DNA
that
was
section, 241 or 252 or something, A? DNA one? What is the section? Some A to 431 or what is it? No, CRPC. 376 charge.
376 hours. my lord.
That is a provision for DNA, I think. Three. Madam Borman, what is that section?
200 something.
Okay, doesn't matter. We'll find it. Then
Then, my lord,
243 as like given.
my lord, in this case, my lord,
Your main prayer is for compensation, isn't it?
yes, yes. Because, my lord, till date, my lord, at least we have to know, my lord, how
The
my son died.
compensation by a writ court is not unknown. It's possible in a case of judicial custody or police custody. But the basics you have to fulfill. It's a deviation from the normal law that you have to prove negligence in a civil court. But still, the writ court, as explained in a number of Catnap decisions, we can
Yes,
still
yes.
go ahead. But we do a fact-finding exercise by referring for a judicial inquiry, which has been done. What is the finding of the inquiry?
Coming to that.
Finding is our favor.
Now, if the finding is there in their favor, you have to make a specific challenge to the finding.
My lord, finding is, my lord,
Mr. Doctor, we are in a slightly, our hands are tied. You have the liberty to challenge.
yes,
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 that,
my
Because that has occasion, because of your filing of this case, that was not earlier happening. You filed a case, we said that you do a judicial inquiry. It's a part of this proceeding. Now, if you say that you are not satisfied with the judicial proceeding, with the inquiry, you can put to challenge in an appropriate manner.
my lord, I have.
Now, in view of
certain
this,
judgment.
how can you now make a submission that this inquiry report should not be accepted if it was in your favor?
My lord, I am not saying that. My submission is.
Let us see the inquiry.
My lord, it's page 31 is the operative part, my lord.
Of the affidavit.
No, my lord, that
No,
is the, this, my lord, inquiry report.
Yes.
inquiry.
They are
Separately given.
Separately given by the registry.
My lord, prior to that, my lord, I just want to point out, my lord, what
First,
is-
let us see the inquiry report. That will be important.
my lord, this court, my lord.
Yes.
23/1/2024, my lord.
This court-
When this court direct for judicial inquiry, my lord, 23/1/2024 order, my lord.
Yes.
Here, the terms of reference for making inquiry was formulated by putting two questions, my lord. First one, my lord, whether there was any negligence on the part of the jail authorities of the district jail Golaghat in providing the adequate medical facilities to the son of the petitioner, which led to the death of the petitioner's son. Number one. Second one, whether the death of the petitioner's son had occurred due to cardiomyopathy along with coronary artery rupture or for any other cause. This is, my lord, important, my lord, or for any other cause.
Yes.
Then, my lord, when the district judge, my lord, conducted the inquiry, my lord,
এটা বন্ধ করে দিও, বেশি ঠান্ডা কি এটা শুনুন না। এটা বেশি হয় নাকি? মানে কত মেডিসিন করে।
in paragraph 23 of the inquiry report,
This is developing. You're reading which paragraph?
My lord, inquiry report, my lord, paragraph 23 is the, my lord,
Finding part.
finding part is 23, my lord.
এইটো separate নেকি নেকি এটাটো আছে ওপৰত নালাগে এইটো দিব লাগিলে কম SP which paragraph page
Last page, my just 31, para 23, please refer.
My lord,
page 30
31 of
my lord,
the
my
inquiry.
lord, may first kindly see my lord page number 30.
13
Page number 30, last paragraph.
30
30, last of the, my lord, the inquiry, my lord.
what is the date of this what is the date of this
23/1/2024. Oh, no, sorry, my lord.
Report
It was 6
of
August
August
2024. 6/8/2024.
Mr. Dr. Saraf, Mr. Sahawala, your matters are in the hearing column. First half, it is not possible. What are these matters?
One is the education income tax matter.
Other side. You can come in the second half. And Mr. Sahawala, same matter.
Now, the next, I have 19 and 20.
What is the
One is
subject?
one is, my lord, the land matter, my lord, and other is, my lord, from bank.
In my matter, there is only a division bench judgment, but I am arguing that there are Supreme Court judgments which were not considered and thereby it.
So the aspect of precedence will come. Per inquirium.
Yes.
Let us try. I will not know how long will this take.
How you lordship may.
Matter of which year? If it is old, then it will be difficult. Old matters will be difficult. Let us see the trend. You can have some of your colleague to be here. If we find that we have time, then we'll call you. Okay. Same, Mr. Sayola?
Yes.
If this takes a bit time, then maybe we'll do some other works. Okay. Aru kita ase hearing? এই দুটা পিছত হলেও কোনো কথা নাই এইটো কিমান দেৰি লাগে ঠিক নাই okay yes please
Yes.
report is dated 6th of August 2024
August 2024. My lord, may kindly see, my lord, page 30, my lord, last paragraph, my lord.
yes
According to Dr. So-and-so, he and his companion doctor ascertained the cause of death of deceased UTP after conducting postmortem. From evidence of the then officer in charge of Gulhat police station, it is found that viscera was not sent to Forensic Science Laboratory Golaghat because cause of death of the deceased UTP was already ascertained by the doctor in the postmortem. Therefore, there is no record in the police station about sending of viscera to the Forensic Science Laboratory Guwahati. Thus, from the above findings of the inquiry, I am of the considered view that there was no any negligence on the part of the jail authorities of the district jail Golaghat in providing the adequate medical facilities to the son of the petitioner, which led to death of petitioner's son, as because during the entire custody period, the said UTP, that is the son of the petitioner, was not suffering from any ailment. But the said deceased UTP has also not made any complaint before the jail authorities or jail doctor about his physical ailment. The death of petitioner's son had occurred due to cardiomyopathy along with artery rupture as per opinion of doctor who conducted the postmortem examination on the dead body of the deceased, that is the son of petitioner. My lord, here, my lord, my submission is that, my lord, because in the postmortem report itself, my lord, the doctor opined, my lord, that to rule out any cause of poisoning, viscera is required to be sent for FSL examination. That means, my lord, the postmortem report is not conclusive one. And, my lord, when the, my lord, they have affidavit was filed on 14/9/2023 by the DIG prison. My lord, there, my lord, they have enclosed one inquiry report by an executive magistrate. There also in that report, it was
page.
My lord, that affidavit on 14/9/2023, my lord.
Perhaps it is page 61 of regular page number, my lord.
61.
Perhaps, because in my page number it is shown as that.
Yes, 60.
Is 61.
First annexure to my affidavit, my lord, filed by the respondent number 2 on 14/9/2020.
Inquiry report.
Yeah,
Yes,
It will be 63.
it starts from page 61, my lord.
No, it's 16, renumbered as 63. Renumbered as 63.
Okay.
Annexure 1, you're referring
Annexure
to?
1. So. Yeah, my lord, I have conducted inquiry regarding the date of so and so at ward
This
number.
is by whom?
This is by.
Report is by whom?
By
Executive Magistrate,
Executive
Golaghat.
Magistrate Golaghat. May I read, my lord?
Just a minute. Yes, please.
My lord,
I have
inquiry.
conducted.
I have conducted the inquiry regarding the date of so and so at ward number so and so district jail Golaghat on 31/7/2012 at 12:40 AM. My lord, regarding the date of UTP so and so in jail ward of district jail, I have taken the statement of Sri Vidyadhar Soikia, jail superintendent so and so, medical and health officer so and so, jail warden convict so and so, Okoni Ali, Raju Bora, Nitul Bora, Dipson Borua. I have also taken the statement of Dr. Rajiv Fukon, who has done the postmortem examination of the dead body of the deceased UTP so and so. UTP was from the village Torpad under Golaghat police station of Golaghat district. He was 30 years old at the time of his death. The name of his father is Sri Jugendranath Soikia. He was admitted into the district jail of Golaghat on 19/6/2012 in connection with GR number so and so under section 376/420 IPC. At the time of admission on 19/6/2012, his medical examination and investigation were conducted as per the proforma for health screening of prisoners by the medical and health officer of district jail Golaghat. As per the report, no external injury and abnormality was detected at the time of medical examination. He has also not any previous history of illness as per the medical record. UTP Kirut Soikia was placed in the ward number so and so of district jail Golaghat. As per the statement of Raju Bora, Okoni Ali, Nitul Bora and Sri Dipson Bora, they also lived in the ward number 1 of the district jail. As per the given statement of Raju Bora, Okoni Ali, Nitul Bora and so, on 31/7/2012 at night about 12:30 AM, UTP Kirut Soikia was found gasping and became unconscious on his bed. By observing the condition of the UTP so jail warden Sri Lokinath Gogoi, who was on duty at that time for ward number 1, 2, 3, 4 and the hospital immediately informed the condition of UTP Kirut Soikia to the jail superintendent, assistant superintendent and the doctor of district jail. After getting the information about the condition of UTP so they all rushed to ward number 1 of the jail. After examination of body of the UTP Kirut Soikia on his bed, the doctor declared that he had already expired. As per the statement of Raju Bora, Okoni Ali, Nitul Bora and Sri Dipson Bora, neither UTP Kirut Soikia said anything about his illness to them, nor they have seen any kind of sickness before his death. According to them, he had a good relation with the other prisoners of the jail. Raju Bora, Okoni Ali and Dipson Bora stated that UTP so was reading a book on that night when they were going to sleep. On 31/7/2000, when UTP Kirut Soikia was breathing abnormally and making some sounds, they were all wake up from their sleep and found that UTP Kirut Soikia was lying unconscious on his bed. As per the death certificate given by medical and health officer of district jail, Dr. So, UTP Kirut Soikia was in unconscious condition on his bed, and after examining, she found that UTP Kirut Soikia had already expired. As per the inquest report, Mohammed so-and-so, Executive Magistrate, Office of the Deputy Commissioner Golaghat opined that according to eyewitnesses and his observation, UTP Khirut Soikia was died due to illness. But to ascertain the actual cause of death, he sent the body for postmortem examination. He also stated that there was no injury mark on his body. The postmortem examination was conducted at KK Civil Hospital, Golaghat. The examination was done by Dr. Rajiv Fukon and Dr. Mukul Sharma of KK Civil Hospital, Golaghat. As per the PM finding submitted by Dr. Rajiv Fukon and so-and-so, UTP Khirut Soikia was died due to syncope resulting from coronary artery insufficiency. Probably
We have
due-
read this, we have read this. He said that in the last line, the cause of death may be due to heart failure, but the final cause of death can be known
Could not be
after
ascertained.
receiving of the FSL report.
Yes.
That is the finding.
Yes, that is the finding. And my lord, this was never sent to the my lord, sent for FSL examination, my lord. So my lord, this report is also not conclusive, my lord. Because my lord, this is remains, my lord, because whether he died due to poisoning or what, my lord. So therefore, my lord, when this court, my lord,
Okay, we will continue at 2 o'clock. Have you got any case laws?
yes, yes.
What case law are you referring to?
My lord, we have already submitted our written argument, and along with the written argument, my lord, I have
Okay,
placed certain
we'll
judgments.
listen. I will complete this.
Lordship, on the,
We were at page 66.
yes,
The report by the executive magistrate.
so Lordship, there, so thereafter, Lordship, on that very day,
Yes,
so that affidavit was filed on 14/9/2023.
which affidavit?
My lord, the affidavit which encloses that
Yes,
executive
yes,
report, that was filed on 14/9/2023.
Correct.
And on that very day, my lord, this court, while passing the order, observed that list this matter again on so-and-so, on which date so-and-so directed to ensure the forensic examination report of the victim is produced before this court, failing which this court shall presume that there is no forensic examination report and consequently draw appropriate presumption. So, my lord, as the FSL examination report could not be placed, my lord, thereafter this
Which
honorable
order are you referring to?
14/09/2023.
Yes, 14/9 is an order.
Yes. But in the last, my lord, may kindly say, failing which this court shall presume that there is no forensic examination report and consequently draw appropriate presumption. So, as my lord, this court, the FSL report could not be placed. So subsequently, my lord, this court, my lord, direct the district judge Golaghat to conduct an inquiry. and by formulating the two terms of reference. The second one, my lord, I am once again repeating, my lord, whether the death of the petitioner son had occurred due to cardiomyopathy along with coronary rupture or for any other cause. Or for any other cause. And my lord, that was passed on by the order dated 23/1/2024.
Yes.
My lord, this question, my lord, whether the death of the petitioner's son had occurred due to cardiomyopathy along with coronary artery rupture or for any other cause. And my lord, the inquiry report that is confines, my lord, only to the extent of whether the death of the petitioner's son had occurred due to cardiomyopathy along with coronary artery rupture. Regarding that remaining part or for any other cause, my to that aspect, my lord, the district judge has neither discussed nor, my lord, opined anything, my lord. Though, my lord, the learned district judge has recorded from the evidence that the viscera was handed over to one constable. Constable handed over the same to the officer, the investigating officer, and the officer in charge in his deposition stated before the district judge that from the case diary it reflects that it was not sent for FSL examination. So, my lord, after filing of the my lord, inquiry report, my lord, I have filed one affidavit, my lord. I have filed an affidavit on 30/10/2024.
Yes.
My lord, my lord, may kindly come to paragraph 11 of my affidavit, that affidavit, my lord.
Yes.
That the deponent begs to state that the inquiry report dated so and so cannot be said to be a conclusive report, as the learned district judge Golaghat has overlooked certain vital aspects of the matter while submitting his inquiry report before this honorable court. Therefore, in order to bring on record certain vital aspect discrepancies, etc., this affidavit has been filed by the answering deponent. That the deponent begs to state that in the instant proceeding, an affidavit in opposition was filed by the respondent number 2 and 3, stating inter alia that the co-prisoner, namely Okoni Ali, Raju Bora, and so, who were lodged in the said ward, stated that on so at the time when they were going to sleep, the son of the petitioner was reading a book. In the meantime, at about 12:30 a.m., the said co-prisoner woke up an unusual hoarse sound coming from the throat of the petitioner's son, and he was found gasping and thereafter laid unconscious in his bed. It was mentioned that duty warden Sri Lokhikanto Gogoi was duly informed, who rushed to see the petitioner's son, who was lying in an unconscious state, and thereupon the doctor examined the son and petitioner at 12:40 a.m. and declared him dead. The said fact was also clearly mentioned by this honorable court in its order dated 23/1/2024. But the report dated 6/8/2024 submitted by the learned district judge Golaghat is silent on this vital point. It seems that the learned district judge Golaghat did not examine any of those co-prisoners in order to ascertain the exact problem faced by the deceased. They were not examined. Or how examined, the truth would have come to light, and it could have come to a conclusion for how long the deceased was suffering before his death, and also for what reasons. Next, my lord, the deponent begs to state that during inquiry, following witnesses were examined by the learned district judge. All total, my lord, 10, my lord. 14, my lord, paragraph, that the deponent begs to during inquiry, the learned district judge examined the present deponent being the read petitioner of the instant read petition, as well as the father of the deceased, the answering deponent in his evidence clearly deposed that after 2 days from the death of his son, he went to District Jail Golaghat to inquire how his son died in judicial custody. Then some jail inmates told him that on that fateful night, his son was reading a book. They noticed his son when he was reading a book. His son also took dinner late, and after that, he made hue and cry and ultimately died. The answering deponent also heard that the cousin brother of the victim was also in the same cell. But the learned district judge Golaghat did not examine any inmates before whom his son made hue and cry in order to ascertain the difficulty faced by the deceased son, as well as to ascertain the actual period of time suffered before his death. That the deponent begs to state that this honorable court, by order dated 23/1/2004, made it clear that to make an inquiry whether the death of son had occurred due to cardiomyopathy along with coronary artery rupture or for any other cause. But in the inquiry, learned district judge Golaghat did not come to a finding that what had actually happened after taking dinner by the deceased. The said aspect would have come to light if the inmates were examined by the learned district judge while conducting the inquiry. It may not be ruled out that son of the deponent might have died due to poisoning. That the deponent begs to state that during inquiry, medical officer Dr. So-and-so, Dr. Rajiv Phukan stated the findings of cardiomyopathy along with coronary.
Yes, we have read this.
My lord?
We have read this, that viscera part.
Yes, viscera part. And their lordship will find viscera were handed over to the escorting police constable
We
Pranab
have read
Sotia.
this, yes.
My lord, so under that circumstances, my lord, the learned district judge ought to have observed and mentioned in his report that non-sending of viscera to forensic science laboratory is a vital lapse on the part of the investigating officer. And it cannot come to a definite finding that death of the deceased was a natural one and same cannot be treated as a case of poisoning, my lord. Accordingly, learned district judge has failed to conclude his report in regard to one of the vital terms of reference, that is the whether the son of the petitioner had occurred for any other cause. So, my lord, it is crystal clear, my lord, that the viscera was not sent for FSL examination and it might be a case of poisoning, my lord. And my lord, in order to, my lord, it may also happen, my lord, in order to protect the jail authorities, my lord, the investigating officer, my lord, he did not forward the viscera to FSL examination, my lord. Otherwise, my lord, if the viscera report comes, my lord, and it says that, my lord, it's not a case of poisoning, then, my lord, I don't have any case. But, my lord, here, as, my lord, viscera was not sent, my lord, so doubt remains, my lord, for what reason the son of the petitioner died. And, my lord, it was the duty of the jail authorities, my lord, to explain, and the respondent, my lord, to know, at least I am entitled to know that, my lord, for what reason, my lord, he was died, my lord, whether it was a case of poisoning or whether it was a normal course of death, that remains, my lord, doubtful, my lord.
What is
To
this?
sum up my argument, my lord, I have just noted down in some vital, my lord, in a concise manner, my lord. My lord, it was a grave procedural lapse, my lord. Despite the postmortem report and magisterial inquiry report, both recommending forensic testing of the viscera to rule out poisoning, the viscera was never sent to the FSL. the investigating officer failed to carry out his crucial step, and this omission was not critically examined or flagged by the learned district judge. And the absence of FSL report precludes any conclusive finding on the true cause of death and creates serious doubt about the integrity of the investigation, my lord. And my lord, the learned district judge failed to examine the co-prisoners who witnessed the last moments of the deceased, though their accounts were recorded in the affidavit in opposition and referred in this honorable court in previous order. The testimonies could have shed light on any symptom, distress, or suspicious circumstance prior to the deceased death. The omission violates the specific direction of this honorable court to investigate, my lord, whether death occurred due to any other cause. And my lord, the ignoring, my lord, the evidence, my lord, which suggests that the possibility of poisoning, my lord, that was not done, my lord. And the medical officer, he himself admitted that viscera was preserved specifically to rule out the poisoning death due to cardiomyopathy. Given the non-submission of viscera to FSL report of the district judge wrongly presumes natural death without examining other possible cause. And my lord, the deceased was a 30-year-old and an adult prisoner with no known health issues at the time of detention. And the state is constitutionally bound to ensure safety and health of persons who is in custody, my lord. And custodial death under suspicious circumstances coupled with procedural lapses suggests a violation of Article 21. My lord, that is one of my submission, my lord. So, my lord, it's a failure of the state machinery, jail authorities, and investigating officer and administrative oversight collectively point toward institutional negligence or willful suppression of fact. So, my lord, my respectful submission is that, my lord, at least some compensation may be granted, and my lord, this matter may be referred to the, my lord, my lord, in light of this lapses or incomplete inquiry, my lord, it may be referred to be investigated by an independent other agencies, my lord.
That is not your prayer in the writ petition. You have expanded your prayer. Your writ petition was confined to making an impartial inquiry. It's already been judicial inquiry.
Judicial inquiry or an inquiry by an impartial
Judicial
agency.
inquiry has already been conducted.
Yes, but my lord, regarding that part, my lord, reference, my lord, whether he was died due to any other cause. My lord, in spite of learned district judge.
That you have already submitted, that will consider.
So, my lord, I have placed certain judgments, my lord, which says, my lord, in spite of there is a finding of the district judge or inquiry report, my lord, this court, my lord, while exercising under
Which one? Which
my lord, the Swarnalota Kolita, my lord. Swarnalota Kolita versus State of Assam. So, my lord, in passing that is this judgment, my lord, the court did not endorse the findings of the learned district judge.
Swarnalota?
Swarnalota Kolita.
Have you given?
I have already given, my lord.
This copy is already with us. This you can have this.
Yes.
This is. You have given one. Yes, Swarna Kolita.
Swarna Kolita, my lord.
Swarna Kolita.
Para 2, my lord. This court by order so-and-so asked the district judge Sibsagar to hold an inquiry and to submit the report. The report has been submitted and the copies have been supplied. I have heard the learned counsel for both the sides. I have perused the report of the learned district judge. My lord?
Yes. Which para you are reading?
Para 4.
Para 4. This is.
I have perused the report of the learned district judge. From the report of the learned district
What
judge.
is the date of the judgment?
6/3/2003.
6, right. Para 4.
Para 4.
Yeah, I have perused.
I have perused the report of the learned district judge.
Yes.
From the report of the learned district judge, the following facts remain admitted. That the petitioner's son, so-and-so, was arrested on so-and-so in connection with so-and-so case. Subsequently, he was shown arrested in connection with as many as 7 police cases under different provisions of IPC. Since there was no separate jail at Soraido, accused so-and-so was lodged in district jail Sibsagar. While in custody
Yes.
in district jail Sibsagar, he died there on 21/10/1999. The dead body of so-and-so was cremated on 22/10/99. Now the points to be answered and formulated below: whether so-and-so died as a result of physical assault committed on him while in custody, while the arrest and detention of so-and-so had been intimated to his family member by the detaining authority, whether the death of so-and-so while in jail was intimated to his family members. From the report of the learned district judge, it appears that the learned district judge recorded the statement of good number of witnesses from both the sides. Learned district judge found the following circumstances in course of inquiry. The younger brother of the deceased was also in the same jail for some time while the deceased was there, but his younger brother never claimed before the learned district judge during inquiry that his elder brother complained of assault having been committed on him by the police or jail officials. There was no mark of external injuries found at the time of postmortem. Though the deceased Prasanto Kolita had been produced before the learned magistrate many times, he did not make any complaint regarding any assault having been committed on his body by any person. The doctor who conducted the autopsy was examined as DWY 11. He deposed that no mark of external injury or ligature mark had been found on the dead body. The doctor found the liver being enlarged and the cause of death, according to doctor, was a cardiac failure. In our case also, it was cardiac failure as per their one part of the PM. DW3 is the doctor who attended the deceased so-and-so before death. He deposed that on his arrival, the deceased was gasping for life and then pushed 2 injections, namely one so-and-so and so-and-so. He further deposed that before the UTP could be shifted to civil hospital, collapsed with 10 minutes. So, though the learned district judge, paragraph 7, though the learned district judge had held that petitioner has failed to establish the allegation of physical torture either by police or by jail authorities, I do not share with his finding, because a young boy like the deceased so-and-so could not die on a sudden cardiac failure unless he suffered some ailment previously. It is also that the liver of the deceased was found to have already been enlarged. Why that has happened, the jail authority did not produce the hospital records showing the reason for such enlargement of liver of the deceased. He was in custody from 2/10/1999 till died on so-and-so. What happened in between had not been divulged either by the police authority or by the jail authority. Admittedly, this is so-and-so, arrested was so-and-so, but the fact of his arrest and detention had never been intimated. Well, this is on the last 4 lines, my lord. 5 lines, my lord. It is not intelligible as to why, instead of serving notice upon the sister of the deceased, any family member was not brought to the morgue where dead body was kept before the cremation, and as such, I am not in a position to endorse the finding of the learned district judge to the effect that it was clarified that dead body had to be cremated since no family member turned up to claim the dead body. The conclusion arrived at by the learned district judge is reproduced below. In view of my finding given herein above, I hold that petitioner has failed to establish that the deceased Prasanto Kolita was subjected to physical torture during the custody. I also hold that dead body was cremated after intimation to the all concerned authorities as well as the family members of the deceased. But at that time, I hold that district jail Sibsagar cremated the dead body in a hasty without waiting for arrival of the family members for reasonable time. 9 is important, my lord. From the aforesaid conclusion, the learned district judge, it reveals that the learned district judge wrongly put the burden upon the petitioner to establish that the deceased was so-and-so was subjected to physical torture during the custody. The deceased so-and-so died on 21/10/1999 while in custody. while he had been in custody since 2/10/1999. There is nothing on record that at the time of arrest and detention on so-and-so, deceased Prasanto had been suffering from any disease which could result in cardiac failure. In our case also, there is nothing of that sort. During post-mortem, liver of the deceased was found enlarged, but there is no hospital record to show that patient or jail authorities made any arrangement for his treatment before his death. In our case,
Yes, please continue.
in our case, my lord, in postmortem, it was opined that it may be a case of poisoning. So to rule out that in direction was given, that was not complied. The cumulative effect of all these omissions on the part of the police or jail authority would lead to a prudent man to infer that due to some foul play committed on the deceased so-and-so, sudden death happened while in custody, and as such, the respondent cannot absolve responsibilities. This was the finding, my lord. And ultimately, my lord, some compensation was awarded of rupees 1,25,000 in paragraph 11, my lord. So, my lord, here I am referring this case, my lord, because, my lord, though, my lord, the district judge report was in favor of the respondents, in
Yes.
support of respondents, but our High Court did not endorse the findings. And by giving this observation, my lord, awarded some compensation, my lord. My lord, one more case, my lord, 2017 2 GLT 636. It was a division bench judgment, my lord, 2017 2 GLT.
Yes.
My lord, paragraph 3, my lord. Paragraph 3 is the facts, my lord, and 13 is the operative part of the judgment. 3, facts in short are these. Bapan Roy was married to Baby Roy on so-and-so. At that time, he was a young man, aged about 32 years, and was also serving as a science teacher in a private English medium school at Silsar. His trouble started from so-and-so when wife Bobby lodged a report against him at Lakhipur police station for an offense under sections 498 IPC. On 11/6/2013 itself, the investigating officer of the case, Assistant Sub Inspector Police so-and-so, arrested Bapan Roy from his house and brought him to Lakhipur police station. He was then remanded to judicial custody on 12/6/2013 and sent to Central Jail Silchar. And from jail, he was taken to Silchar Medical College Hospital on 13/6/2013, when he was declared dead, brought dead by the doctors. The dead body of the Bapan Roy was handed over to so-and-so on 14/6/2013, after it was subjected to postmortem examination. According to postmortem examination report dated so-and-so, his cause of death was due to organophosphorus insectable poison, my lord. That was a case of poisoning, my lord. And in this case also, my lord, the inquiry was conducted. I will not like to trouble your lordship in referring the other judgment, only paragraph 13, my lord. A 13, my lord, a survey of the cases referred above, my lord, the Nilavati Behra, DK Basu, that judgments were discussed. Survey of the cases referred above goes to show that it is now well settled that the defense of sovereign immunity is not available when the state or its officers acting in the course of employment infringe a person's fundamental right of life and personal liberty as guaranteed by Article 21 of the Constitution. And the state can be directed in a jurisdiction under Article 32 and 226 to repair the damage done to the victim by paying appropriate compensation. In the case at hand, as mentioned above, Bapan Roy was aged about 32 years and was newly married. He was arrested on 11/6/2013 for a minor offense under section 498 of the IPC code by the police of Police Station Lakhipur, whereafter he was sent to jail on 12/6/2013, and in jail he died an unnatural death between 12/6/2013 and 13/6/2013. We therefore, considering these facts, direct the state government to pay his complainant father Badal Roy compensation of rupees 5 lakhs within 2 months from today. We have awarded this amount as compensation, feeling that amount is just and proper. While doing so, we, as held by the Supreme Court in the case of D.K. Basu, we have not taken into account the punitive element, as the objective is to apply balm to the wounds of the victim's father and not to punish the transgressor. We, however, make it clear that if the father Badal Roy feels dissatisfied with the amount awarded, he will be at liberty to resort to traditional remedies, and the compensation awarded in present case will be adjusted against any amount awarded to him by way of damages in civil suit. In order to unravel the truth regarding unnecessary mysterious death of Bapan Roy in jail, and also to prevent similar victimization of prison, we direct the District Jail Kasar Silchar to hold an inquiry into the matter and submit a report within 3 months to the Registrar General for information. The District Judge Kasar shall have also submitted a copy of report to the Principal Secretary, Government of Assam, Home and Polity for information and taking appropriate action. Another one also, my lord, where, my lord, in spite of District Judge report, my lord, this court has not endorsed the findings, my lord, that Bohagi, Sutia and others versus Union of India. Para 1 and 2 are the facts, my lord. Yes. Also, paragraph 1 and 2, my lord, that comprises the fact, my lord. Paragraph 1, my lord, by way of this petition under Article 2, the petitioner have prayed for the following main relief. My lord, in the premises, therefore, it is most respectfully prayed that your lordship may be pleased to admit this petition, call for the records, issue a read in the nature of certiorari, calling upon the respondent to show cause as to why the so and so the impugn inhuman action of the respondent killing 2 youths of Deep Moran and Deepjudi Setia. So it was a case of, my lord, some torture was over the person, my lord, injured victim, my lord. In cold blood by Indian Army shall not be declared illegal and unconstitutional and without any authority of law, and or as to why writ in a nature of mandama shall not be issued directing the respondent's authority to produce post-mortem report and inquest report, and for institution of judicial inquiry and or investigation by an agency such as CBI or investigation by any agency such as or a judicial inquiry to investigate into the killing of the 2 deceased, namely so and so and so and so, by Assam Rifles along with other 11 issues that may be referred to during such inquiry, investigation, and or on causes being shown, and upon hearing the parties may be pleased to make the rule absolute and pass appropriate orders for prosecution of offending personnel of the Assam Rifles vis-a-vis concerned state police personnel, and further give directions.
Now, why are you referring to this?
My lord,
Yes.
in this case also, my lord, paragraph 12, my lord. My lord, just above the paragraph 12, my lord.
Yes.
Considering the entire facts
Hmm.
and circumstance of the case, we direct that the present district judge Dibrugarh to conduct an inquiry into the incident
Yes.
which took place in the morning of.
Yes, inquiry was also conducted by.
Inquiry was conducted, and my lord, paragraph 12, my lord, as per the said order, learned district judge Dibrugarh made a detailed inquiry and
Then
has
we have read
submitted his
this,
report.
then come to 13.
Yes.
Report submitted by district judges based on cogent material. They have
Yes.
agreed with the finding.
Yes. As opined by the learned district session judge Dibrugarh, about 11 boys and girls were assembled and were to cross over to Myanmar to join Alpha, and the learned inquiry officer has come to the conclusion that Assam Rifles.
So how are the facts applicable? Here
But the
the.
facts is different, my lord.
Then?
I am not on the facts, my lord. But my lord, in paragraph 16, my lord may kindly see, however, the facts remains that the young youth.
In firing.
Yes, lost their lives in firing, and the petitioner, as their kith and kin, would be entitled to appropriate
So
compensation.
that is what we are asking. How is the principle applicable here?
My lord, my submission is that, my lord, the in district judge report says that it's not a case of, my lord, firing, my lord, as a result of
No,
firing.
no, not said. No, not said.
My lord, when they were asked to stop,
No,
my
no,
lord,
that
they
is
did not
that in
stop.
the firing by Assam Rifle operation. For purpose of see number 8.
13 also it is mentioned that
13.
fire was offended.
Report submitted by the district judge on cogent is based on cogent materials. They have agreed upon.
Yes, they agreed upon, and but my lord, as because, my lord, they were died due to, my lord, during the however
was dead by firing.
It was dead by firing, my
Not
lord.
in judicial custody. Not even in police custody. They were running, trying to flee. They were fired.
Yes, but my lord, other two cases which I have referred, my lord, in that case, my lord,
No,
there was
those
no
cases we have not put the question to you. We have put the question only on Bohagi Chutia. How is it relevant? Okay, next. Any more?
My lord, one,
Bohagi
my
Chutia
lord,
not help you.
Veduki Bura Guhai, my lord.
Eduki
Bura
Bura
Guhai.
Guhai. Yes. Yes, please.
Yes, my lord, 15 paragraph, my lord.
1-5.
1-5. Having found that the deceased died in jail custody, we would now turn to petitioner's claim for payment of compensation due to death of her son. Normally, a party who demands compensation for custodial death has to go for action under the private law, but this is not so in all the cases. The judicial activism has evolved the public law remedy.
This principle is long-term laid.
Yes,
down.
yes.
That's not.
I'm just referring just to, my lord. My lord, regarding that public law remedy, my lord, this judgment I have referred, my lord. Paragraph 18 also says, my lord, what we have been made to understand, better
Yes.
say directed by the apex court, is that in the process of judicial activism, a writ court in a proof case of custodial death should, under the public law remedy, direct the state to pay just compensation to victim or his next of kins by way of monetary amends and redressal without affecting the party's right under the private law remedy. My lord, only for this purpose, I am referring this case because, my lord, here, my lord, what I am, my lord, my some is that, my lord. Now, several, my lord, procedural lapses were there, my lord, because, my lord, the postmortem, in the postmortem, my lord, it was clearly mentioned that, my lord, it was required to be sent for FSL and it was not sent, my lord. So, my lord, definitely, my lord, in order to protect the jail authority so that the actual truth may not come out, my lord. Therefore, my lord, it was not done. And my lord, the cumulative effect of all, my lord, it suggests that it's a case of, my lord, custodial debt, and for which, my lord, the state is liable to pay some compensation. And
Yes. Yes, madam. Anything more, Mr. Doctor?
I would like to point out 2, 3 things, my lord.
We will
Nothing
complete
much.
it.
my lord, my lord, as the, my lord, this, my lord, vital mistake of not sending the viscera, my lord, that cannot be considered as an, my lord, unintentional mistake, my lord. And on such conduct of the investigating officer, my lord, I humbly pray to hold it an attempt to suppress the, my lord, real facts of the cause of death, my lord, cause of death. And under these facts and circumstances, my lord, I humbly submit that the cumulative effect of all these omissions on the part of the police or jail authorities that would lead to a, my lord, prudent man to infer that due to some foul play committed on the deceased and sudden death happened to the son of the petitioner while he was in custody, my lord. I am obliged, my lord.
Facts has already been revealed by way of.
Just a minute, just a minute. Yes.
Facts has already been revealed through the pleadings, my lord. So far as, firstly, I would like to submit, so far as that cardiac arrest is concerned, my lord, postmortem report has very much clearly revealed the reason of death, my lord. It is not that there any reason for any scope for doubtfulness, my lord. For rule out any poisonous thing happen with that inmate, my lord, that viscera part was directed to be sent for FSL, my lord, which could not be sent as it is revealed from the inquiry of the district magistrate, my lord. The official concerned, though he was put to notice before to appear before the magistrate, my lord, during the inquiry time, in the meantime, he died, my lord. So actual facts could not come out why it was not sent for FSL, my lord. But so far as negligence part is concerned regarding give any immediate medical assistance to the person concerned, my lord, it is not such there. Because if we go by the timing of the occurrence, my lord, on that fateful night, my lord, that he got an cardiac arrest at 12:30, my lord, as per pleading reveals, my lord, and the reports also. Immediately he is informed the warder, and accordingly medical assistance has been provided to the person deceased, my lord, and by 12:40 he was declared dead by the jail doctor, attending doctor, my lord. So had it been any negligence part or without any assistance of doctor, then it would have been a clear cut case of negligence, which would not have been, my lord, as nothing has to be provided in the name of medical assistance to the person concerned, my lord. But no such thing has happened. There was no any scope for providing any such further more treatment or any medical assistance. By the time the person concerned died, my lord. And so far as non-calling of the other inmates, my lord, on the basis of which that facts reveals that while he was reading a book in the custody in the prison, my lord, all of a sudden he got attacked. Those person concerned, he has very much participated in the magistrate inquiry, my lord. Those, he did not provide any requisition for calling those inmates, my lord, though magistrate was not put to notice those inmates, my lord, which proceeding, which already has been, which versions have already been recorded in the pleading, my lord. Though, so now he cannot say that it is an intentional part to give a safe rider to the authority concerned for providing a safe hand to rule out that negligence part or anything, my lord. None of that inmates has been called by or by requisition by petitioner concerned, my lord, as his petitioner has already participated in the inquiry, my lord. And so far as poisoning part is concerned, my lord, in a
But this is not a this is not a court proceeding.
court proceeding, my lord, but if he had some kind of a presumption or some kind of a, my lord, he has noticed that if those would have been revealed the actual facts, that if that person concerns or inmates would have been called for, he could make a prayer before that authority concerned, my lord, in my humble prayer. As so far as poisoning part is concerned, my lord, all the inmates were provided the same type of foodstuff to the in the jail concerned, my lord. Had it been any poisoning thing, my lord, it could not have been done to only the petitioner's son, my lord. Other could have also been affected, my lord, to an extent, if not more like that person concerned. But so far as cardiac arrest is concerned, my lord, it always comes for a sudden effect, my lord. And moreover, my lord, prior to happening of his death, my lord, on the fateful day, the very previous day, he was brought before the magistrate, my lord. No complaint of any kind of negligence or any kind of ailment or not providing any medical assistance in spite of his information to the concerned authorities. Nothing has been stated before the magistrate concerned, my lord. So here, it cannot be said that anything that he was suffering from any kind of ailment or any kind of illness, my lord, which was not attended duly by the jail authorities or, my lord, jail warder or any, not attending any, not provided any medical assistance regarding his health issues, my lord. And so far as, my lord, not sending viscera, it is admitted fact, my lord. I am not denying it. A magistral inquiry and as well as district inquiry has also, district judge inquiry has also revealed that, my lord. And I cannot go beyond the findings of district judge inquiry, my lord. It is an impartial inquiry. And so far as facts and circumstances related to the cases, my lord, my learned friend has referred, it is slightly different, my lord. Here, that time span of date is not as such so small, my lord. So factual part, it doesn't apply, my lord, in my humble submission.
Which case?
In both the cases, that Swarnalata and other, my lord, which that honorable court has given compensation, my lord.
Swarnalata, let us say Swarnalata.
Factual aspect are, though magistrate, district judge inquiry, after district judge inquiry, court has revealed, my lord, given a compensation, my lord. Though it was, death was occurred in judicial custody, my lord.
What is your contention? What are you trying to contend by saying that span of time is
That
different?
Occurrence of death, my lord, cardiac.
In Swarnalata?
No, my factual part, my lord. in a case at hand, my lord, in the instant case, my lord,
Yes.
that timing is, occurrence happened within 10 minutes, my lord.
Yes.
So such short span of time, my lord, as a doctor has attended, my lord, them without any negligence, my lord. And by that time, person concerned date, my
No,
lord.
that is not the purpose why Swarnalata has been.
It is,
It
got
is
it,
on
my
the
lord.
purpose that in spite of there being an inquiry report.
After in the favor of respondents, honorable court has provided
Yes,
compensation.
yes. What do you say? What do you want to content? What do you want to join on this?
That, my lord, as that procedural part could not be established to because the date of that person, my lord. So it cannot be ascertained whether any lapse or on the part of particular person concerned official, why he has not sent that viscera, my lord, to the FSL report, my lord. So I cannot deny that it was not signed, my lord. And moreover, that finding at paragraph 23, last paragraph of inquiry, my lord. In my written argument, my lord, 4, 5, and 6, I have submitted my, at point number E, my lord, reply I have already written as I have submitted my.
Point number?
Point number E, my lord.
Page?
My written argument, page 4, 5, and 6. 6, sorry. Point-wise objection made by the petitioner in his affidavit, my lord.
Yes.
These are my humble submissions.
My lord, in reply to that, my lord, whether, my lord, the UTP was, my son was died due to poisoning or the cardiac arrest, that remain, my lord, doubtful. My lord. That cannot even unearth from the inquiry report also, district judge report. Therefore, my lord, I humbly submit, my lord, this honorable court may not endorse the findings of the inquiry report submitted by the learned district judge. I am deeply obliged. Lord.
An inquiry report, my lord, is not put to challenge in any further petition, my lord. It's in by an independent authority, my lord, so I have to rely, I am relying. Though objections are there, it is not put to any challenge.
We are under, my lord, public law remedy. It's my
Obviously.
Reserve করুন। M. Dutta. I am Bormon, government advocate, conclude reserve. Okay, we'll consider.
Obliged, man.
Okay.